All right. Morning, everyone. I think y'all can hear me. I'm trying to start my video. Give me just a second. All right. I think we should have all of our judges. Let me just make sure. Matt, you're here. Rhonda, we've got Lenny, and then Tara. All right. Outstanding. Well, I think we've got all of our judges. Before I admit our participants, am going to try and add my number into the chat so that if something happens during the course of the round, y'all know how to reach me, okay? We're live streaming, otherwise I would just tell y'all what it is, but perhaps we don't want my phone number on YouTube. Okay, so that should be it. Hopefully y'all have gotten it. If at any point in time y'all have technical issues during the round, I do have my cell phone. I will be telling our participants in case they see me. I'm required to keep time during the rounds. And so if y'all see me looking down and kind of looking around, that's what it's for. And I'll also keep it propped up so that if anybody has technical difficulties and needs to call me, I'm available. Okay, so before we let our participants in, does anybody have any questions? Matt, what about you? Anything? Going once, going twice? Okay,
Nothing.
Rhonda?
Nope, I'm good.
Lenny?
No, thank you. I'm good.
And Tara?
I'm all set.
All right, well then let me go ahead and let our lawyers in then. We've got, let's see here. Carolyn is right here. Carolyn, how do I pronounce your last name?
Morning, Your Honor. It's McGuigan.
McGuigan. All right. Good morning, Miss McGuigan. Welcome. Thank you for joining us. And then I believe your co-counsel is with you as well. Is that correct?
Yes, Chehek Goja, she's here.
Good morning.
Good morning.
I don't see yet that I have our other.
I don't see plaintiff's counsel yet either.
So we'll give them just a minute or two before I raise the alarm. I've told our judges already, hopefully y'all can still see it. I put my phone number in the chat. So to the extent that y'all have technical difficulties during the round, you'll have the ability to contact me. All right, it looks like we've got one of our.
Your Honor, I don't see your number. Would you be able to drop it again?
Yeah, let me make sure just in case. Let's get all of our participants in and then I'll type it in again. So it looks like we now have Miss Smith. Miss Smith, you're with us?
Good morning, Your Honor. I am Ms. Forrester's second chair.
All right, and are you aware of Miss Forrester's location? She's not yet joined us yet?
She should be here any minute.
All right, lovely. While we're waiting for our final participant, Ms. Forster, to join us, let's go ahead and just confirm with our judges. Y'all are each aware that we'll be following the federal rules during the course of the trial. Is that correct? Y'all have reviewed the pretrial order?
Yes.
Okay, lovely. Just wanted to make sure. All right, Ms. Forrester, thank you so much for joining us. I think with you, we have everyone that we need to proceed. So with that, I am going to go ahead and call this case, assuming any of my judges need a break before I call this case. All right, then at this time we will begin. The court is going to call cause number TG-CV-001-21, Jordan Gilmore versus Chimes Department Store Incorporated, now pending in the District Court, 170th District Court, McLennan County, Texas. If I can have appearances at this time on behalf of plaintiffs' counsel.
Good morning, Your Honor. My name is Jenna Forster. I'm joined today by my co-counsel, Cheyenne Smith. Together, we represent the plaintiff, Mr. Jordan Gilmore.
Welcome. Thank you so much for joining us. At this time, if I can ask for appearances as well as on behalf of the defense counsel.
Good morning, Your Honor. My name is Carolyn McWiggin, and I'm here today on behalf of Chimes Department Store Incorporated. I'm joined by my co-counsel, Chehet Goja.
Thank you very much. It's a pleasure to have each of you as well. We are going to turn to address pretrial matters before I permit the parties to make their opening statements. Let me begin with plaintiffs' counsel. Ms. Forster, are there any matters you desire to bring up with the court prior to us beginning openings?
Yes, Your Honor, just one note about technology, and that is, since I've never had the pleasure of appearing in your Zoom courtroom before, when we're dealing with exhibits, if we'd like to offer an exhibit into evidence, is it permissible for us to share it on the screen constructively outside the view of the jury in order to lay the foundation? Or would you prefer that we not share until it is fully in evidence?
I would prefer for you to take the first approach so that our scoring judges will have the opportunity to see the exhibits and understand the content while y'all are making your arguments. Anything further, Ms. Forster?
Yes, for documents that are already admitted, would you like us to ask to publish before we share them on our screen, or is that not necessary?
As long as you'll notate for the court that those have already been agreed upon, then you're more than welcome to share them.
Understood. That's it for housekeeping. We have a few substantive matters, but I'll let defense counsel go ahead if they have any housekeeping.
Let me go ahead and turn to defense counsel and their housekeeping. Ms. McGuigan?
Yes, Your Honor, we do have one additional housekeeping matter. Today, we intend to call an expert witness, Perry Hayden. So we wanted to ask Your Honor's preference when we are tendering. Mr. Hayden, do you prefer that we lay the foundation pursuant to 702 and then make a formal motion to tender, or that we lay the foundation and then proceed directly into the opinions without making a formal motion?
I would like a formal motion to tender, please.
Yes, Your Honor. That's
Any
all.
further housekeeping matters?
No, Your Honor.
All right, let me, as a matter of housekeeping as well, prior to our participants joining us, I did put my phone number in the chat in case anybody has technical difficulties. I'm going to do that again at this time for the participants. Again, if anyone has any technical difficulties at all during the course of the trial, which are very common, please don't panic, just call. I will also note again for our participants, I am required to keep time for everyone during the round. I have been advised we have 5 minutes for pretrial and 70 minutes for case in chief. Just to confirm, Ms. Forster, does that meet with your understanding as well?
It does.
And Ms. McGigan?
Yes, Your Honor.
All right. So if you see me looking down during the course of the trial, I'm paying attention to you, but I am required to keep your time. And so I just want everybody to know you do have my full attention throughout this, but I'm trying to make sure that I'm meeting my obligations to you. All right. So with that, I am going to go ahead, I think, before we turn to our substantive pretrial, and ask for each of our scoring judges, if you can please turn your video off at this time so that I can hide you as non-video participants, and that way we'll have our litigants here. All right, I think that we have accomplished that then. So then let us turn to our substantive matters. Ms. Forster, I'll begin with plaintiffs first.
Yes, Your Honor. First things first, before today's trial, we were able to meet and confer with defense counsel and agree to pre-admit, with Your Honor's permission, quite a long list of exhibits. I'm happy to give Your Honor all those numbers.
Bear with me just for a second. I need to turn in my pretrial list to your exhibit list. All right, you may proceed at this time.
The exhibits we've agreed on the admissibility of are 1 through 7,
Continue.
11 and 12, and 16 through 35.
So to confirm 8, 9, 10, 13, 14, 15, and then 36, 37, 38, 39, and 40 are not agreed, and the parties will be discussing those should they be attempted to be admitted during the course of trial. Is that correct?
That is correct.
All right, anything further?
Yes, Your Honor. At this time, we'd ask Your Honor to take judicial notice of a few legal code provisions that were the operative law in effect in Waco at the time that the accident occurred in January 2019. I can go ahead and share those on the screen for Your Honor.
Have you already discussed with opposing counsel those that you're asking for me to take judicial notice of?
Yes, we have.
And let me confirm as well, is there an agreement for the court to take judicial notice?
Yes, Your Honor.
All right, then you may go ahead and share your screen. All right, I can see these code provisions. I'm writing down the numbers. Is there anything further at this time as it relates to these?
Not as it relates to these.
All right, then you may proceed, Ms. Forster, if there's anything else that you appear to take up during the course of our pretrial.
Sure. At this time, plaintiff moves for a ruling regarding the admissibility of Exhibit 14. Now, by way of brief background, this is a slip and fall case in which the plaintiff got hurt at the defendant employer's workplace. Exhibit 14 is an incident report that was prepared by the defendant about another employee getting injured on the exact same steps in the exact same place 10 years before the plaintiff did. We'd ask for a ruling regarding the admissibility of Exhibit 14 because plaintiff believes that it is admissible because every part of it has a hearsay exception or exemption, and it is otherwise admissible.
Response?
Yes, Your Honor. If there are hearsay exceptions, then we need to hear the foundation as to what those are. We cannot simply rule here that it's admissible if those exceptions are not laid out. We would argue that this document does contain multiple instances of hearsay. The majority of it is based on statements made by the employee in question. As such, those are hearsay that should not be admissible today.
The court will take that up during the course of the trial, and you may broach those issues when we reach that document. It becomes necessary to attempt to admit it. Anything further, Ms. Forster?
Nothing further.
All right, defense counsel.
Yes, Your Honor, we do also have a couple substantive motions. First, we move to preclude Exhibits 8 and 9 under Federal Rule of Evidence 403. These are pictures of the plaintiff Jordan Gilmore's knee immediately after he had a knee replacement surgery. Your Honor, as this is a bifurcated trial, anything beyond a simple statement that the plaintiff was injured and needed surgery clearly goes to damages. Furthermore, Your Honor, given that these pictures were taken directly after the surgery, they show Mr. Gilmore's knee in the worst possible condition that it can be in. It is newly stapled up. It is swollen. That is certainly not what it looks like today. So the fact that the plaintiff is bringing these pictures rather than any other pictures of Mr. Gilmore's knee clearly shows that these will only be used to inflame the passions of the jury, and as such are not admissible here when this is a bifurcated trial.
Are you able to show me those pictures?
I can show them to you, Your Honor, yes. If you just give me one moment. Your Honor, this is Exhibit 9,
Okay.
and this is Exhibit 8.
All right, and response to the 403 objection?
Yes, Your Honor. I'll start by saying we understand that this is a bifurcated trial. We do not intend to spend too much time discussing this, but we do believe the photo is important for two reasons. One, as Ms. McGuigan has noted, the plaintiff does have the burden to show that there was an injury in today's case, and this photo is probative on that point. Secondly, one of the elements in the claim today, one of the elements of negligence, is whether or not there was an unreasonable risk of harm created by the conditions in the defendant's workplace. Now, the fact that such a severe injury could have resulted from those conditions, that is circumstantial evidence that goes to show that there was an unreasonable risk of harm created by those conditions. So it's also admissible on that point.
All right, and any further response from defense counsel?
Yes, Your Honor, only that we are happy to stipulate that the plaintiff was in fact injured, that he injured his knee and needed a total knee replacement. Anything beyond that is not necessary to meet the requirement to show injury here today, and therefore goes to damages.
And the court's response at this time will be, I'll again take that issue out during the course of trial as we see the evidence develop. However, I will note to my litigants at this time, certainly more than one photo the court would find to be duplicative, and you may address that as we go forward. Ladies, if I might ask you a question before we press forward, in your prior rounds, were your scoring judges also present on your video?
No.
Not for mine, Your Honor.
Okay, I just wanted to make sure. There was a question about whether or not their video should be turned on. And so I thought, since you had been in prior rounds, you might be our best people to ask. All right, so then defense counsel, anything further in pretrial?
Your Honor, just on your last ruling, we would ask then for a limiting instruction that those pictures cannot be used in opening statements.
The court will grant that request.
Additionally, Your Honor, we move to preclude Exhibit 37. This is a proposed OSHA regulation that was never put into effect that discusses guardrails on loading docks. It is discussed in the deposition of Perry Hayden, the defense expert. Your Honor, given the fact that this was never put into law, and here today in this case, we will be discussing several both OSHA and International Business Code regulations. We move to preclude this under 403, as it will confuse the jury as to what is and is not a regulation and mislead them to make conclusions in this case based on things that are not in fact in effect.
In response?
Plaintiff does not intend to offer this document into evidence. The only way we might use it is we have a good faith belief that defense counsel is going to call an expert witness today who relied on this proposed rule. And so pursuant to Federal Rules 703 and 705, if it is necessary to probe the bases of that expert's conclusions, we'd like to be able to mention this proposed rule to do so. But we do not expect that we're going to have to offer it into evidence to do that.
Certainly, at this time, I'll allow counsel to probe the expert's opinions. Should this rule become necessary in connection with that, we can address the issue at that time. So again, I'll make a similar instruction to each of you. You should ask to approach constructively, and we will discuss it should it become necessary in connection with the expert's testimony. Anything further?
Your Honor, can I ask on that note, if I intend to offer one of the photos we were discussing earlier of the plaintiff's knee, should I ask to approach before I do that as well?
Yes, please do so.
Will do. Thank you.
Finally, Your Honor, the defense moves to preclude Exhibit 40 as impermissible hearsay. Your Honor, Exhibit 40 is an email sent from Kermit Realty LLC. They are the landlord that owns the space that Chimes Department Store leases and operates its store out of. Your Honor, this email was sent after this litigation had already begun. Therefore, there are serious questions as to its reliability, and therefore it should be precluded as impermissible hearsay.
In response?
This document is admissible under 801 D2D as adoptive admissions of a party opponent. Reese Geller, who is the defendant's owner, was deposed in this case. In that deposition, Mr. Geller said that he did not disagree with any of the statements in this email. The statements in this email, therefore, are adoptive admissions of the defendant. And even if not, Your Honor, I'd like to be able to use this document if necessary to impeach Mr. Geller.
Can I hear a response on the adoptive admissions argument?
Your Honor, this is not an adopted admission. When Reese Geller was asked about this email, he says, well, he can say whatever he wants, kind of sometimes like the rantings of a crazy, kind of sounds like the rantings of a crazy person to me. That is not agreeing with the contents of this email at all. Furthermore, Your Honor, the defense is absolutely going to contest the contents of this email today, mainly who had control over the area in question.
Your Honor, may I respond just briefly?
Of course.
The question and answer just below the one that Ms. McQuiggan just read says, question, but do you dispute any of his claims in this email? Answer, no, but it doesn't matter.
Ladies, are you able to show me the full email on the screen? All right. And Ms. McQuiggan, can you read me the deposition testimony again, both the lines that you referenced as well as the lines that Ms. Forster referenced?
Yes, Your Honor. Beginning on page 13, line 3, is Exhibit 40 a true and correct copy of that email? Answer, yes, it is. What do you have to say about this email? Well, he can say whatever he wants. Kind of sounds like the rantings of a crazy person to me, but he should go read the lease. because I think the language in the lease is very clear. But do you dispute any of his claims in this email? No, but it doesn't matter. We have a lease and they should live up to it.
All right. At this time, the court will decline to find that these are adoptive admissions. However, Ms. Forster, during the course of the trial, you may certainly make other arguments in connection with it, but I will decline and reject that argument at this time. Anything further, Ms. McQuiggan?
Nothing further from the defense, Your Honor.
Okay, and let me, Ms. Forster, just confirm, do you have anything further for pretrial at this time?
Nothing further. We're ready for openings.
At this time, we will turn and I'll invite plaintiff to proceed to opening statement. Thank you very much, Ms. Forster.
Your Honor, I'm going to take just one moment to adjust my camera, if that's okay.
Absolutely. Please take all the time that you need. Ms. Forster, are you prepared?
I am.
Please proceed.
Simple steps. The defendant could have taken simple steps to keep its employees safe, but it didn't. We are here today because of the defendant, Chimes Department Store. Chimes operates a store right here in town, here in Waco. You may have seen that store. You may have parked in the parking lot, browsed up and down the aisles, checked out at the register. But where you probably haven't been, what you probably haven't seen, is the area behind that store. It's an area that looks like this, and this, and this. Peeling paint, crumbling concrete, a missing railing, a door that blocks the walkway. Oh, there is a light, but no one can figure out how to turn it on. You will hear today the defendant required its employees to use this area. They had to use this area to take out the trash. They had to use this area if they were going to smoke a cigarette on a break. You'll hear the defendant could have taken simple steps to make that area safe, but it didn't. I want you to meet someone. Mr. Gilmore, if you could turn on your camera for just a second. Folks, this is Jordan Gilmore. He is the plaintiff in today's case. He's my client. He's also a former employee of the defendant, Chimes Department Store. He'll tell you that on January 23rd, 2019, he was walking up those same steps you just saw when he fell. He shattered his knee. Thank you, Mr. Gilmore. The story starts years before that day in 2019. It starts all the way back in 2005. You'll hear today that 2005, well, for Chimes, that was a good year. Business was good. They were looking to expand. They moved to a new location. And they still sit in that location on Bosque Avenue, right here in downtown Waco. When they moved to that location, you'll hear that that back area that you just saw looked a little different. It looked a little more like this. There was a railing around that back landing and along those back stairs. But you'll hear that 2 weeks after the defendant moves in, they decide that railing has to go. They get in touch with their landlord. They ask for that railing to be removed. And then that landing looks like this. You'll hear once that railing is removed, they start to use that area as a loading dock. They back up trucks to the back of the store, and they can unload merchandise there and take it into the store. But you'll hear that even after they started using that area as a loading dock, they did not stop using it as a place for employees to take their breaks. They did not stop using it as the only way for employees to take out the trash. You will hear today that that area could be dangerous. You'll hear that there was a light out there, but no one could get it to work. You will hear the defendant knew that that area was a risk. There were simple steps they could have taken. They didn't. Fast forward to January 23rd, 2019. Jordan Gilmore's been working for the defendant for 10 years as a cashier. That night around 7 p.m., he goes out onto that landing with a friend, a coworker. Now, Mr. Gilmore is someone who has always done his best to follow his employer's rules. That's why he's out there in the first place. That's the only place his employer lets him smoke. And that's why he doesn't just stand on that landing in front of those open doors. He walks down the steps into the dark. Because he knows that if he stands on that landing and smokes his cigarette, if that smoke gets in the store, he knows he could get in trouble. Mr. Gilmore smokes his cigarette. He throws the butt in the dumpster. He goes to walk back up those stairs. But the door, it's right in his path. And his coworker is on the other side, trying to brace that door open, trying to give Mr. Gilmore as much light as she can, because the light outside doesn't work. And as she's trying to brace that door open, and as Mr. Gilmore's trying to come up those stairs, he is left with just 12 inches of crumbling concrete between the edge of that door and the edge of that dock. He does his best. He takes a step. And he falls. He lands on his right side, on his knee. That knee is shattered. You'll hear today it required a total replacement. That is the reason that we are here today. That is why Mr. Gilmore is bringing a claim of negligence against the defendant. Now, it's the plaintiff who has the burden today. We have to prove to you, and we will prove to you, 3 elements. 1, that the defendant's workplace created an unreasonable risk of harm. 2, that the defendant knew or should have known about that risk. And 3, the defendant didn't use ordinary care to address that risk, to protect its employees. You're going to hear today from Mr. Gilmore about exactly what happened to him. And you'll hear that in the moments after he fell, as his coworker helped him up, helped him get up those stairs into that store, the first thing he did was go to his manager and tell her that he'd gotten hurt on those steps. You will hear her response. Yeah, probably should have fixed those stairs a long time ago. The evidence will show they knew about the problems. They just didn't fix them. And you will hear today not just that those stairs were dangerous, folks, but that they were actually illegal. You'll hear expert testimony from a professional engineer named Kelly Danes. She's going to tell you those back steps, that back landing, it broke not 1, not 2, but 3 laws. Folks, the evidence will show today those stairs were unreasonably dangerous. Now, you are going to hear from a lot of witnesses. You're going to hear a lot of evidence, but by the time you get to the end of this case, you will see it is really not all that complicated. You will see that this case is as simple as every one of the simple steps the defendant could have taken to keep their employees safe. At the end of this trial, I'll have a chance to come before you again. I'll remind you they didn't take even one of those steps. And I'll ask you to hold them accountable. Thank you.
Thank you, Ms. Forster. If I can invite defense counsel to come forward for opening at this time. All right, Ms. McGigan, are you prepared to proceed?
I am, Your Honor.
You may go forward. Thank you.
Jordan Gilmore had a terrible accident. You're not going to hear us say any different today. Now, we understand wanting to hold somebody responsible for that accident, but today the plaintiff will try to pin responsibility on the wrong party. Because Chimes Department Store did not control that loading dock, and they did not control the plaintiff's actions. Today, the evidence will show that it was the landlord, Kermit Realty LLC, who actually controlled that area, and that it was the plaintiff who controlled his own choices. No control, no responsibility, no liability. Now, before we go any further, I want to take a few moments to tell you a bit about Chimes Department Store. Chimes is a small town store located right here in downtown Waco. It's a family business. It was started 2 generations ago by a husband and wife. And today, Reese Geller, their grandson, still owns and operates the store. You're going to hear from Reese today, and he's going to explain how Chimes rents its storefront on Bosque Avenue from a company called Kermit Realty LLC. You're going to see their lease, and you're going to see that under that lease, the space that Chimes rents, the space that they are responsible for, well, it ends with the back wall of that store. The space beyond that wall, the space where the plaintiff fell, well, that's a common area. And common areas, you'll learn, are the responsibility of the landlord, not Chimes Department Stores. Now, today the plaintiff's not going to be able to prove anything to the contrary. Instead, they're going to call Kelly Danes, a mechanical engineer who's been paid thousands of dollars to come and give her opinions here today. But money or not, Kelly Danes will not be able to tell you anything that solves this threshold issue, that Chimes didn't control that loading dock. So right then and there, this case is over. Because without control, there can be no responsibility and there will be no liability. But then, members of the jury, Kelly Danes is also not going to be able to show you that there was actually anything wrong with the way that loading dock was maintained. She's going to discuss some regulations with you today from the IBC, the International Business Code. Now, when you see those regulations, I want you to look at them and ask if they apply to the person who does not control that space. Because members of the jury, you're going to see that the IBC, it applies to whoever controls the space in question. So if Chimes didn't control that space, well, then they aren't subject to the IBC. And then Kelly Danes may also talk to you about OSHA regulations. Now, those are federal workplace safety regulations that companies have to follow to keep their employees safe at work. And if she does that, I want you to listen to whether or not those regulations apply to loading docks. You will learn that they don't. And that means they do not apply in this case. Now, we, on the other hand, are going to bring you Perry Hayden, an actual OSHA investigator whose job it is to know and understand those regulations and determine whether or not workplaces live up to them. He's going to tell you that in 2018, he inspected the Chimes department store. He saw that landing that the plaintiff claims is so unreasonably dangerous. He saw the concrete. He saw that there were no railings, and he issued no citations. You'll learn that's because this landing, it was a loading dock. It had been one since Chimes moved in, and they've been using it as one ever since. So that means that even if there were regulations that apply, well, the responsibility for living up to those regulations, it fell squarely on the shoulders of the landlord. Chimes department stores had nothing to do with it. They won't be able to show control, and they won't be able to show any violations. No control, no responsibility, no liability. And then there's one more thing you're going to have to consider today. The unfortunate truth that Jordan Gilmore's own choices are what actually caused his injuries. Now, we're not saying that Jordan Gilmore is a bad guy. We're not saying that he acted egregiously. He just made a mistake. It was dark, it was cold, and he went out back for a smoke. He went down the stairs he'd gone down thousands of times before. He smoked a cigarette, and he came back up. As he came up, he could see that that door was half open, but rather than ask his coworker Riley to open it all the way, rather than ask her to close it, rather than ask her to move, the plaintiff chose to try to scoot around that half-open door, stepping to the edge of a landing he knew had no railing. Unfortunately, he fell and injured himself. But members of the jury, today you'll see that was the result of his own failure to exercise ordinary prudence. Chimes department stores had nothing to do with it. At the end of this trial, I will come before you again, and by then you will have learned three things. First, this loading dock was in a common area, so the landlord, not Chimes department stores, was responsible for maintaining it. Second, the regulations that you will hear about today do not apply to loading docks. And third, it was the plaintiff's own choices that actually caused his injuries. The landlord had control over that loading dock, and the plaintiff had control over his own choices. None of the control lied with Chimes department stores. Without control, there is no responsibility and there can be no liability. And so I will ask that you return the only verdict that the evidence supports and that justice allows. A verdict finding Chimes department stores not liable.
Thank you. At this time, is plaintiff prepared to call his first witness?
Yes. Plaintiff calls Jordan Gilmore.
Mr. Gilmore, if you can please come forward and raise your right hand. Sir, do you solemnly swear that the testimony you shall give and the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, if I can ask for you to please put your hand down, if you'll again state your full name and spell it as well for our record.
Jordan Gilmore, JordanGilmore.
Thank you. Ms. Forster, your witness.
Thank you. Good morning, Mr. Gilmore.
Good morning.
Could you tell us just a little bit about yourself?
Well, like I mentioned, my name is Jordan Gilmore. I live here in Waco. I'm 49, just recently turned. Been here kind of all my life, born and raised.
Do you work?
I don't. I haven't worked since the fall.
What fall?
That was when I fell at Chimes, the place where I used to work.
We're going to come back to that fall in a few minutes, but you mentioned Chimes. What is Chimes?
So Chimes is a department store here in Waco. So think Macy's, Sears, they just kind of sell a little bit of everything. And that's where I worked at my last job.
What did you do at Chimes?
I was a cashier.
And how long did you do that?
I was at Chimes for 10 years.
You mentioned you stopped working there after you fell. When was that fall?
That was January 23rd of 2019.
Can you tell us where roughly in the building that fall happened?
So it occurred on the landing at the back of the building over by where the dumpster is.
I want to talk about the landing at the back of the building. I'm going to show you Exhibit 2, which is already in evidence. Is this a photo of that area we're talking about?
Yes, it is. This is the landing that I mentioned.
The landing, is that the platform in the center of the photo?
Yes, right in front of where you can see the double doors.
Speaking of those double doors, where do those lead?
Those lead into Chimes itself.
Now, I can see in the upper left-hand corner a red circle. What is that circle indicating?
So that's a light that's placed kind of above and pointed down towards the landing.
I'm going to come back to that light in a bit, but first I'm going to show you Exhibit 17, which is already in evidence. Are these the same stairs that we were just looking at?
Yes, this is a closer kind of zoomed in view to those same stairs next to the landing.
When did you usually use these stairs?
So I use them whenever we had to take anything out to the dumpster to throw any trash away, or whenever I was taking a smoke break.
Thank you, Ms. Smith. I want to talk a moment about that. You said that you use this area to take out the trash. Was that something the defendant required you to do as part of your job?
Yes, that's where the dumpster was. So we were required to take the trash out back to that dumpster.
As far as you're aware, was it normal for the defendant's employees to be in that back area?
Yes.
Did you ever see anyone from the defendant's landlord company in that area?
No, not that I can remember, no.
Do you even know who that landlord is?
No, I don't. I'm sorry.
No problem. Back to that landing, about how many times would you guess you went out there per week?
I'd say it was about 20 times per week, once a day to smoke, and then 2 or 3 to throw things away as the need arose.
Now, did you ever have to go out there when it was dark?
Yes, I did. Sometimes we have trash, or I'd take a later smoke break.
Now, you showed us that light that was circled in red. So if you were going outside in the dark, could you turn that light on?
No, I couldn't.
Why not?
Well, there was no switch for that light in Chimes. It was in one of the other buildings.
Did you ever tell a manager of the defendant that you didn't have a way to turn that light on?
Yes, I did. Several of us employees did.
And when several of the employees brought up this issue to management, what did they say?
They said that Chimes didn't have a switch for that light inside the store, so there was nothing they could do.
Mr. Gilmore, did you ever once in your 10 years of working at Chimes see that light turned on?
No, I did not. It was off whenever I went out there.
Well, if that light didn't work, did the defendant ever put a lamp outside so you could see?
No, it didn't.
Did the defendant ever offer you a flashlight to take out there with you at night?
No.
I want to talk about another part of that landing, and that's the steps. Was there any kind of railing on those steps at any point during your employment?
No, there weren't.
Was there any kind of handrail on the wall on the other side?
No, there wasn't anything on the wall.
Can you describe for the jury the condition of those steps?
So they were kind of worn down. They were decently old. And then especially towards the edges, some of the corners had kind of fallen off and there were holes where railings used to be.
Now that the jury understands what the landing looked like, I want to talk about the day you got hurt. Now, you said it was January 23rd. Do you remember what time it was?
Yes, it was around 7 p.m. I was working the noon to 8 p.m. shift, and it was kind of towards the end of that shift.
So 7 p.m. in January. Was it dark outside?
It was. The sun usually set around 5 or 6 around that time of year.
And did you go out there alone?
Actually outside, yes, but one of my coworkers was standing kind of in the doorway, holding the door open.
Why didn't you also stay on the landing?
Well, because I was taking a smoke break, and I was worried that with the wind that was kind of going on that night, that my smoke would get blown back into the store, and I didn't want that to happen, so I walked to the bottom of the stairs.
Why didn't you want that to happen?
Well, because the whole point of having a smoke in the back was not to bother the customers, so I was worried that I was going to get in trouble if some of that smoke got back into the store and messed with some of the customers' noses.
At some point on that break, did you finish your cigarette?
Yes, I did.
What did you do at that point?
Well, I threw away the butt and then walked back up the stairs.
What happened as you were walking up those stairs?
Well, I tried to get back into Chimes itself, and I fell from the stairs.
Now, I want to slow this down and make sure the jury really understands how this happened. I'm going to show you Exhibit 3, which is already in evidence. We're going to use this picture to walk through how that happened. Now, is this photo taken from the top of that landing?
Yes, it is.
You've already told us that your coworker was standing in the doorway. Can you describe where that would be using this photo?
So it'd be on the right side of this photo, kind of on our side of the door. That's where Ryan was standing to brace it.
I'm going to mark an RH for Riley Huntsberger. Does that accurately reflect where your coworker was standing?
Yes, it does.
Where were you when you were smoking your cigarette?
I was at the bottom of the stairs, kind of center left of the picture.
I'm going to mark a JG, kind of center left at the bottom of the stairs. Does that accurately reflect your testimony?
Yes, it does.
Now, when you finished your cigarette and you start coming back up these stairs, is this the position that that door is in?
Yes, this is pretty much the exact same angle that Riley had it.
Why?
Well, because Riley was bracing the door against the wind that night.
So if Riley was bracing the door against the wind, why didn't Riley just let the door close entirely?
Well, because then we wouldn't have had any light out there. The only light we had was coming from inside Chimes itself.
So as you are walking up these steps, your coworker's bracing the door, trying to give you some light. What happens?
Well, I tried to go around the outside of the door, kind of on the left side in this picture, and my foot ended up slipping off of the landing itself, and I tried to end up landing on my feet, but my right leg took most of the force and then ended up on my backside on the ground.
What did your coworker do after you fell?
Riley came over and checked to see if I was all right and helped me to walk back into the store.
When you got back into the store, did you tell anyone what had happened?
I did. I told my manager.
When you told your manager you had fallen on those steps, what did the defendant's employee say?
She said, yeah, we probably should have fixed those stairs a long time ago. I've brought it up with the owners a few times, but we always have some bigger problems to fix, I guess. Sorry about that.
Did you have to go to the hospital?
I did.
Plaintiff requests a sidebar at this time.
Counsel, you may approach.
At this time, we'd like to revisit, we intend to offer Exhibit 8 at this time, which is the picture of Mr. Gilmore's knee after the surgery that he had to have as a result of this injury.
And defense counsel, anything further in addition to the argument you made previously?
Your Honor, we just re-raise our objections. These pictures were taken directly after a major surgery. The knee is swollen. It is not healed. They will be very inflammatory to the jury. Furthermore, Your Honor, Mr. Gilmore has already testified that he fell and hurt his knee and had to go to the hospital. That is in evidence, and it is sufficient to make a showing of injury so as to meet that prong under the requirements for liability here today.
Ms. Forster, to confirm, you're only moving to admit at this time Exhibit 8, correct?
That's correct.
The court's going to overrule the objection and allow admission of Exhibit number 8. You may proceed, Ms. Forster.
Thank you. Mr. Gilmore, I'm going to show you constructively outside the view of the jury for the time being, Exhibit 8. Is this a photo of your knee after you went to the hospital?
Yes, it is.
Is it fair and accurate?
Yes, it is.
Plaintiff offers Exhibit 8.
Shall be admitted.
Mr. Gilmore, did you have to have your knee replaced?
I did. It was kind of beyond the point of just fixing it by the when I got to the hospital, so they ended up replacing it completely.
I want to move on. I want to ask you, why were you taking your smoke break out in that back area in the first place?
Well, because that's where we had to take our smoke breaks. If we were going to take them at all, they had to be in that area.
Is that something the defendant had communicated to you?
Yes, that's something they told all the employees.
How did they tell you that?
In an email memo that got sent to all of the Chimes employees.
We're going to show Exhibit 1, which is already in evidence. I know it's a little blurry at the time being, but does this look like that memo?
Yes, it is.
We're going to show you an enlarged portion of the first paragraph. Ms. Smith is going to highlight. Mr. Gilmore, if you could read this highlighted portion for the jury.
If you're going to smoke, you need to smoke out behind the store where our dumpster is. That is the only place that you should take smoke breaks on the premises.
In this email where the defendant requires you to take smoke breaks in this back area, do they warn you that there's no railing in that area?
No, they don't.
Do they warn you that the steps are crumbling in that area?
No.
Do they warn you that the light in that area isn't working?
No, they don't.
Do they offer employees a flashlight?
No.
Do they warn employees about the condition of that landing at all?
No, they don't.
Thank you, Mr. Gilmore. I pass the witness.
All right. Defense counsel, you may proceed with cross-examination.
Yes, Your Honor. Good morning, Mr. Gilmore.
Good morning.
I want to start by talking a bit more about the area where you fell. You fell outside the back exit of Chimes department store, right?
Yes.
That's where the loading dock is.
Yes, that's the landing that I fell from.
In fact, you fell, as you said, off of that loading dock.
Yes.
Loading docks are where a business receives shipments, right?
Yes, they are.
You would agree loading docks don't have railings.
No, I don't know of any that do.
You'd agree you can't put a railing on a loading dock, right?
Not as far as I'm aware.
Now, this loading dock, you went out there often, right?
Yes, I did.
That's where you threw out trash,
Yes.
and you do that once or twice a day.
Yes.
As you've said, that's also where you went to smoke.
Yes, that's where they required us to take any smoke breaks.
You would go out there to smoke at least once a day while you were at work.
Yes.
Between the garbage and the smoking, you were out there about 20 times a week.
Yes, that sounds about right.
It's fair to say you were pretty familiar with that loading dock.
Yeah, I'd say that's fair to say.
That includes the stairs.
Yes.
That includes the lighting.
Yes, it does.
And that includes those doors.
Yes.
So I want to talk now about January 23rd, 2019. Towards the end of your shift that night, you went out to that loading dock to smoke.
Yes.
Now, you said on direct you had to go out there if you were taking a smoke break. But sometimes you would smoke in your car during the workday, right?
Yes, if I wanted to go all the way back out to my car, then I could. But if I was staying on Chimes's premises, then I had to be back in that area.
And that night, you didn't go out to your car, correct?
No, I didn't. It was freezing. I didn't want to make the walk.
Well, you went out to smoke. It was about 7 p.m.
Yes.
And at that point, the sun had set.
Yes, that's correct.
It was nighttime.
Yes.
It was dark.
Yes.
In fact, it was pitch black.
Yes, it was, besides the light coming in from Chimes.
Now, you knew that that light in that area, it was controlled by the store next door, right?
I believe that's right. Yes.
And as you said, the only light you had was coming from inside the store.
Yes.
Your coworker, Riley, she was with you, right?
Yes, she was holding the door open.
She also was coming out to take a smoke break, though, right?
Yes, she did.
And as you said, she stood in that doorway,
She did. Yes.
but you went down the stairs.
Yes, I didn't want the wind to blow any of my smoke back into the store.
And you smoked your cigarette at the bottom of the stairs.
That's right.
And then you went back up the stairs.
Yes.
You were outside for about 6 minutes, right?
It sounds about right. Yeah.
You wanted to get back inside as quickly as possible.
Yes. Like I said, it was very cold.
Right, it was very cold. So, Mr. Gilmore, now I want to move to after you finished your cigarette. When you were done, you came back up those stairs.
Yes, I did.
At that point, that back door was still propped open.
Yes.
I'm showing you what's already in evidence as Exhibit 3. As you discussed on direct, that door was propped open like this.
Yes.
And you were coming up these stairs on the other side of this door.
Yes, the side that's kind of blocked by the door in this picture.
When you were coming up those stairs, you could see the door was blocking most of the landing, right?
Yes.
You could see there was only a small space to get around that door.
Yes.
And you're aware this door opens further than we see in this picture, right?
Yes, it does.
It opens all the way.
Yes.
Showing you what's already in evidence as Exhibit 6. When that door is open all the way, it looks like this.
Yes, it does.
There is a lot more space for someone to come up those stairs and onto that landing.
There is, yes.
Now, when you were coming up those stairs on January 23rd, you didn't open that door all the way.
No, I did not.
You didn't ask Riley to open that door all the way.
No, she was still holding it against the wind.
So that's a no to my question, right, Mr. Gilmore?
No, I didn't ask her to open it further.
You didn't ask her to move back out of the doorway where she was standing.
No, I didn't.
Now, if that door had been closed all the way, there also would have been a lot more space for you to walk up onto the loading dock, right?
Well, yes, but then there wouldn't have been any light.
Well, directing you back to my question, there would have been a lot more space for you to walk up, right, Mr. Gilmore?
Yes, there would.
If that door was closed all the way, it wouldn't have blocked your path.
Yes, that's correct.
You could have asked Riley to close the door all the way.
I could have.
You didn't ask her to do that.
No, I did not.
You didn't ask her to move the door at all.
No, I did not.
Instead, you tried to step around the half-open door, correct?
Yes.
And that's when you fell.
Yes, it is.
No further questions, Your Honor.
Thank you. Redirect.
No redirect.
Then our witness may be excused at this time. Thank you. Ms. Forster, your next witness.
Plaintiff calls Kelly Danes.
All right. And if I'm correct, Ms. Danes or Mr. Danes is being called. Oh, there we are. All right. Thank you for joining us. If I might ask for you to please raise your right hand. Do you solemnly swear that the testimony you shall give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth? So help you God. If you can please turn your audio on.
Yes, Your Honor, my apologies. I do.
Thank you very much. And if I might ask at this time, if you can please state your full name for the record as well as spell it.
Yes, my name is Kelly Danes. It is Kellydaynes.
Thank you. Ms. Forster, you may proceed.
Thank you, Your Honor. Good morning, Ms. Daines.
Good morning.
What do you do for a living?
Well, I am a professional engineer.
Do you have an educational background as a professional engineer?
I do. I went to school. I went to the University of Wisconsin and got my engineering degree. And then I passed some of the certification exams and began and worked 4 years as a certified engineer.
How many years in total have you been working as a professional engineer?
As a professional engineer, about almost 14, a little over 14.
At the beginning of your career, did you work as a practicing engineer?
I did. I worked for about 4 years as a practicing engineer.
And is that the same kind of thing you do now?
Well, I've kind of transitioned my career. I'm more of doing investigations and compliance work as an engineer.
What kind of investigations and compliance work? Is that why you're here today?
It is.
Are you being paid for your time here today?
I am.
Were you paid for your work on this case?
Yes, ma'am, I was.
And just so the jury knows, have you and I worked together before?
We have on a prior matter.
How many investigations have you done in your career?
Investigations over or around 60 different investigations.
Did you do an investigation of the workplace at Chimes Department Store, the defendant company?
Yes, that was what I was brought on to do, and that's why I'm here today.
Now, without telling us yet what your conclusions were, did you come to any conclusions?
I did.
What materials did you have to reach those conclusions?
I reviewed the depositions of the defendant, Mr. Geller, that was taken, and then of the plaintiff, Roy or Gilmore. And then I also reviewed different OSHA and IBC regulations and conducted an investigation and took photos while conducting that investigation, which I reviewed when coming to my conclusions and in order to determine what those were.
And was all of that sufficient to reach your conclusions?
Yes, it was.
What kind of methods did you use?
I use the methods that are set forth for professional engineers in order to come to conclusions while conducting investigations like I did in this case.
Plaintiff offers Kelly Daines as an expert in engineering and workplace safety compliance.
Is there any objection?
No objection, Your Honor.
Okay, there being no objection, she shall be admitted as an expert on those two topics. You may proceed, Ms. Forster.
Ms. Daines, why don't you go ahead and tell the jury what your conclusion was in this case?
Well, there's three main areas that the defendant really failed and provided unsafe work environment. And that was they failed in the railing, in the door, and in the lighting that was out on that loading dock.
I want to talk about those areas one by one. You said railing, door, and lighting. So we're going to go ahead and start with the railing. You told us you reviewed regulations in this case. What do those regulations require with respect to a railing?
With railings, with those specific OSHA and IBC regulations, they require that there be a railing on stairs that are higher than 30 inches or platforms that are higher than 30 inches. So they would require railings to be on the outer, exposed side of those stairs.
Would those regulations have applied here?
Yes, for OSHA regulations, those apply to employers, and then IBC is the International Building Code regulations, and so for those would require just because this is a building, and so that's how they would apply.
Let me ask you, are railings required around a loading dock?
While these specific regulations that I reviewed don't explicitly state they be around a loading dock per se, they do say for platforms that they need to be on there.
Do you believe that this area was a loading dock?
No, I don't.
Why not?
Because you can see from my investigation and the photographs that I took during this investigation that this was a set of stairs. And when you compare it to other, I guess it was a shopping center, so other different stores that inhibit the other places within the shopping center, those had set out loading docks versus a set of stairs. And you could see where a railing used to be. So it shows that originally it wasn't for a loading dock.
Objection. Your Honor, this is in violation of Rule 26 as this opinion was not disclosed prior to trial.
Well, the witness has already made the testimony and we'll go ahead and move on, but you can feel free to lodge additional objections to the extent that counsel asks about that opinion.
Yes, Your Honor.
Ms. Daines, did you conclude that the lack of a railing violated the relevant laws in this case?
Yes, I did.
And I want to move on to that second issue you raised, and that was the door. Is that right?
That's correct.
What does the law require with respect to this door?
With respect to the door, it requires that the door not block more than a certain amount of inches on the set of stairs, that it not that it allow for a pathway to go when it is extended.
We're going to show you Exhibit 3, which is already in evidence. Did you take this photo?
I did.
And we can see that the door is extending at least partway into the walkway. Does this comply with that regulation you just mentioned?
No, it does not. It, as you can see from this photo here, it leaves just about 12 inches as a pathway there. It's covering, as you can see, the majority of the rest of the stairs.
We've talked about the railing, talked about the door. I want to move now to that third issue you raised, the lights. What does the law require with respect to lights around building exits?
Well, both OSHA and the IPC require that there be a light that illuminates and provides light for exits outside, leading out of a building.
This might be a silly question, but was this a building exit?
Yes, it was clearly a building exit.
And what did your investigation tell you about the lighting around that exit?
That there was none. That whatever light that was there was no switch for it to turn on. And that, as Mr. Gilmore said here today, that he had told them that that light was not working for them. And so it was never taken care of. They knew and they were aware that a light should have been there, but on that night it wasn't.
Now that we've talked about those three problems you raised, the railing, the door, the lights, I want to ask you about some steps the defendant could have taken to fix those problems. I'm going to use a demonstrative to do that. I want to ask you first, would a railing have helped make that back area safer?
Yes, it would have.
Would a handrail against the wall have made that back area safer?
Yes, while not required, it sure, in my opinion, would have made it safer.
Would fixing that broken outdoor light have made that area safer?
Yes, and following code as well.
Would putting a lamp outside have made that area safer?
Yes, it would have.
Would offering a flashlight to employees have made that area safer?
Yes, I think so.
Ms. Daines, based on the results of your investigation, did the defendant take any of those steps?
No, honestly, I don't know what the defendant was doing here, but they didn't take any of those steps.
Thank you very much. Pass the witness.
Thank you, Ms. Forrester. Cross-examination?
Yes, Your Honor. Good morning, Ms. Daines.
Good morning.
I want to start by discussing the area in question in this case. It was used as a loading dock, right?
Well, just because you call it a loading dock and use it as it doesn't mean it is one, but yes, that's what they used it for.
Well, you yourself just called it a loading dock on direct examination, correct?
Well, I called it that because that's what it's been identified as in this case here today. I also called it an exit, a designated exit to the building as well.
Now, Ms. Daines, you would agree if there were railings on that loading dock, then it couldn't be used as a loading dock, right?
Yes, that's probably why they took the railings off.
Because you use a loading dock to receive large deliveries.
I guess you can, yes.
And you can't accept large deliveries if there are railings in the way, right?
If you are intending to receive them on a loading dock, then yes, I would agree with you.
So I want to talk about the regulations you discussed on direct as they apply to loading docks. On direct, you said that OSHA and the IBC require this loading dock to have guardrails, right?
I said that OSHA and the IBC require platforms higher than 34 inches to have a guardrail. Yes, that's what I said.
And therefore, based on that, this platform, according to you, should have had a guardrail.
Yes, because I do not believe, it's not my opinion that this was a loading dock.
Okay, well, the IBC, Ms. Daines, that's the International Business Code.
It's the International Building Code. Yes.
Building Code, my mistake. Thank you, Ms. Daines. Now, you said on direct, the regulations that you were talking about, they don't explicitly state that these guardrails be around loading docks per se, right?
Yes, around loading, designated and built loading docks, correct.
So those regulations, they don't discuss loading docks.
They don't state that railings have to be on loading docks. Yeah.
Now, one of those regulations that you're talking about, that's IBC 1012.1, correct?
Yes, that is one.
Okay, so let's look at 1012.1 right now. This says at the top, International Business Code 1012.1, right?
Yes, it does.
It says guards shall be located along open-sided walking surfaces, mezzanines, industrial equipment, platforms, stairways, ramps, and landings, which are located more than 30 inches above the floor, right?
That is what it says, yes.
And then down after that paragraph, it says exception.
You mean on the second round? Yes. It
Yes.
does.
Can you read the first exception for us?
Let me make it bigger on my screen. I don't have my glasses on. Yes, it says on the loading side of loading docks or piers.
So this regulation, it does talk about loading docks.
It talks about loading docks, yes.
Which is not what you said on direct.
No, what I said on direct was that it doesn't state that they are that they are required on buildings, but that's what it doesn't say.
But as you just agreed with me a few moments ago, the regulations, as you said, that you talked about, do not discuss loading docks. That is what you said a few minutes ago, right?
That is how you recall it.
That is what you said, though, Ms. Daines, right?
That is not how I recall stating it, but sure.
Are you telling me that you don't recall the answer you gave only a few minutes ago?
I recall what my answer was, and that I'm not necessarily in agreement with you.
Okay, Ms. Daines, let's move on. All of that said, you can't point to any OSHA regulations that regulate how employees should place guardrails around loading docks, right?
Well, I don't believe employees are supposed to place guardrails around loading docks.
My mistake, Ms. Daines, I misspoke. You can't point to any OSHA regulations to how employers should place guardrails around loading docks.
No, but again, counsel, I am not of the opinion that this was a loading dock. This was a set of stairs that was an exit to this building.
Ms. Daines, I'm not asking you what you thought this loading dock was. I'm asking you whether you can point to any OSHA regulations that talk about how employers should place guardrails around loading docks, and you cannot, correct?
That is correct.
You cannot point to any portions of the IBC related to how employers should place guardrails around loading docks, correct?
That is correct.
You can't point to any OSHA regulations that indicate if employers should place guardrails around loading docks.
That's correct.
And you can't point to any IBC regulations that indicate if employers should place guardrails around loading docks.
That's correct.
You can't point to any standards or any regulations at all that require employers to put guardrails around loading docks.
That's correct. But again, this was not a loading dock.
That's a yes to my question, right, Ms. Daines?
Yes.
All right, now I want to switch gears a little bit. You're a litigation consultant, right?
That is what part of what I do. Yes.
You run your own litigation consulting firm.
Yes, I do.
You've been doing that for 10 years now.
I have.
Before having your own firm, you worked for another litigation consulting firm.
Yes, I did.
Preparing expert opinions for lawsuits like this one, that's about 99% of what you do, right?
Preparing opinions and testifying and at both depositions and in court as we're doing here today. Yes, that is all combined about 99% of what I do.
So all combined, that work, it makes up 99% of what gets you your paycheck, right?
That is correct.
Your paycheck in this case, it was over $5,000 before you gave your deposition.
I believe so. If I look back to my invoice, yes.
And then you were paid for your deposition.
That's correct. Yes.
And you're being paid for your testimony here today.
Yes, ma'am, I am.
You were also paid for all the work you did in between your deposition and this trial here today.
Yes, that's a lot of prep work that goes into me being able to be here today.
For all that prep work and all the deposing and all the testimony, you're being paid $750 an hour, right?
Yes, I am.
And you're being paid by the plaintiff.
Yes.
You were hired by their lawyers.
Again, yes, that's correct.
You've worked for them before.
I have on a different matter, as I said earlier.
They've paid for your opinions before.
They've paid for me to conduct an investigation and come to conclusions, yes.
Now, Ms. Daines, I want to talk finally about who the regulations that you've discussed here today actually apply to. You don't know who was responsible for maintaining this loading dock, right?
That's correct. That's not what I was hired to do. I was hired to investigate the actual site.
That's right. So you don't know who was responsible for repairing that loading dock.
Well, I do know from an OSHA standpoint that an employer is responsible for maintaining that area. They are required to provide their employees and anyone who comes on the property with a safe and hazard-free premises.
Directing you back to the IBC regulations that you discussed on direct, Ms. Daines, you don't know who was responsible for repairing this loading dock.
Again, that's under the IBC, and I discussed both OSHA and the IBC. So yes, while under the IBC, I don't know for certain. That is not my expertise, and I'm not going to come here and give an opinion which I'm not qualified to give. But under OSHA, I do know that it would be the employer that would have to repair it if it was making that place unsafe for employees.
All right, Ms. Daines, so I want to focus on the IBC regulations. All of those regulations that you talked about today, they apply to whoever has the responsibility to maintain that area, correct?
That is correct.
So if Chimes wasn't responsible for maintaining this area, none of those IBC regulations would apply.
That's correct.
Now, if this was a common area and the landlord was responsible for maintaining it, all of those regulations, they would apply to the landlord.
Again, I don't know. That's not what I'm here today to do. I'm here today just to investigate. I'm not here to decide or to talk about whether it was the landlord when I don't know. That wasn't what I'm here to do.
Ms. Daines, you just agreed with me that those regulations apply to whoever controls the space, right?
Yes, but in trying to put someone else or to say it was someone else when I don't know, I'm not qualified and I'm not comfortable giving my opinion here today.
I'm just asking you a hypothetical, Ms. Daines. If you agree that those regulations apply to whoever controls the space, and if the landlord controls the space, then those regulations would apply to the landlord, correct?
If you're asking a hypothetical, then yes, that would be correct.
Now, the OSHA regulations that you've spoken about today, those are federal safety standards?
That is correct.
And you don't have a degree in safety compliance technology?
No, I don't.
You don't have a degree in environmental technology compliance?
No, ma'am.
You've never worked in code enforcement at any level of the government?
No, ma'am, I have not.
You've never attended any training in OSHA compliance?
No, ma'am, I have not.
You've never reviewed any internal OSHA guidance on compliance?
No, ma'am, I have not.
You are not an OSHA inspector.
No, again, I've spent my career in private practice, not with the government.
Now, because of that, you've never done an OSHA inspection.
I've done many compliance investigations that involve OSHA regulations. So while it's not been a OSHA investigation, because I've never worked for the government, I have done investigations that involve OSHA regulations.
Directing you back to my question, you have never done an OSHA inspection, correct, Ms. Daines?
Objection, asked and answered.
I'm going to allow the witness to answer the question.
No, ma'am.
You've never even shadowed an OSHA inspector while they do an inspection.
No, ma'am, I have not.
Now, all those investigations that you said you have done, you haven't done thousands of them?
No, ma'am, I have not. I've done about 60.
You'd agree with me, 60 is a lot less than 1,000.
Yes, I would agree with you.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor.
You may proceed.
Ms. Daines, I want to clear up the issue about the loading dock versus the stairs. Do the relevant laws require a guardrail on stairs?
Yes, they do.
Was there a guardrail on these stairs?
No, there was not.
Thank you very much for your time. Nothing further.
Thank you. Anything further, defense counsel, for this witness?
Nothing further, Your Honor.
Thank you very much, Ms. Daines. You're excused at this time. Let me ask, Ms. Forster, does the plaintiff have any further witnesses to present or evidence to proffer at this time?
No, Your Honor, we do not.
My understanding is then that those are going to be the only witnesses that plaintiff's counsel will be presenting before we transition to defense counsel's case in chief. Are there any motions that need to be made outside the presence of the jury?
Yes, Your Honor. Before we move on, the defense moves pursuant to Federal Rule of Civil Procedure 50A for a directed judgment. Your Honor, viewing the evidence in the light most favorable to the non-moving party, at this point, a reasonable juror could not find that the plaintiff has made a prima facie showing upon which a liability can be found. Your Honor, as a threshold matter, we have already shown that Chimes department store was not in control of this area. And if they are not in control, then they cannot be responsible and they cannot be liable. Because as we have heard, the International Building Code, it applies only to whoever controlled the area. And Ms. Daines just had to agree with me reluctantly on cross-examination that that would mean that if Chimes department stores did not control that area, then they were not responsible for following those rules. Therefore, Your Honor, if control cannot be established, then this case is already over. So the motion should be granted in favor of the defense.
Any further response, Ms. Forster?
Yes, Your Honor, I'll say this. The law states that you can prove control through actual control. And Mr. Gilmore told us today that the defendant required their employees to use this area and that he had never seen anyone from the landlord company in this area. In fact, didn't even know who the landlord was, Your Honor. We have shown enough for a reasonable juror to find that it was the defendant who had actual control over that area.
Thank you. I'm going to deny defense counsel your motion at this time. We will take a brief recess before we turn to defense counsel's case in chief. And when I say brief, everyone gets a 5-minute bathroom break, and then I need everyone back here. And I will just ask so that I can confirm that I have all of my scoring judges back. When you return from your bathroom break, if you can please turn your video on. I'm starting the timer now for 5 minutes. Everyone go.
Thank you, Your
Thank you, Your Honor.
Ms. Forrester, welcome back. We'll wait as everyone else comes back on. Do you want to do a time check with me while we're waiting for everyone? I have thus far that you have 37.5 minutes remaining. And then Defense Counsel, I have that you have 45 minutes remaining. I don't know if your teammates have also been helping keep time. Are there any challenges to time at this time?
I'm going to take just one moment to confer with my co-counsel, but I believe that should be all right.
Okay. And same thing for defense. Do y'all have any challenges to time? Again, I have 37.5 minutes remaining for plaintiff, and I have 45 minutes remaining for defense.
Your Honor, that sounds about right to us. Thank you.
All right. And then it looks like we have all of our judges back. So wonderful. Thank you everyone for being so prompt. I'm very appreciative. To confirm anything, Ms. Forrester or Defense Counsel, that we need to take up outside the presence of our jury before we return to Defense Counsel's case in chief.
Not from the plaintiff.
All right, then I'm going to go ahead and ask each of my judges to please turn your video and your sound off, and we will return to our round at this time. Counsel, you may call your first witness.
Yes, Your Honor. At this time, the defense calls Perry Hayden to the stand.
Mr. Hayden? Welcome at this time, sir. I'm going to go ahead and ask if you'll raise your right hand. Sir, do you solemnly swear that the testimony you shall give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? You'll have to speak just a little louder while you're together with us during Zoom. At this time, if I can ask for you to go ahead and state your full name. And we are having a difficult time hearing you. So I don't know if it's a microphone issue or if it's a volume issue, but if I can ask for you to adjust that.
Your Honor.
Thank you very much. Everyone, please be patient. I want to ensure that we're able to hear the witness's testimony before we press forward, because I think that might make it difficult for y'all both to ask questions as well as objections.
Thank you, Your Honor.
Is it any better now, Your Honor?
You're muted, Your Honor.
It still sounds very muffled. You almost sound as if you're speaking from underwater. Counsel, if you feel differently, by all means, please chime in. I'm not able to hear this witness as clearly as I was the other witnesses. Do you concur?
I do.
I agree.
Your Honor, you can try one more thing.
Okay.
Your Honor, can I just confirm that our clock isn't running for these technical issues?
It's absolutely not. I have not started a time yet for your first witness.
Thank you, Your Honor.
Counsel, while we're working through our technical issues, let me go ahead and just inquire. I know that one of the components of our trial this year will be our charge. Oh, let's try this again, actually. Are we able to hear you now?
Testing, testing. Any better?
Oh, so much better. We can hear you loud and clear. All right. So then let's go ahead and take this from the top. I'm going to ask you to raise your right hand one more time, sir. Let me ask, do you solemnly swear that the testimony you shall give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Wonderful. And if I can ask at this time, if you'll please state your full name as well as spell it for our jury.
Perry Hayden, Perryhayden.
Thank you. All right, then counsel, your witness, you may proceed at this time, and I will begin your time now.
Yes, Your Honor. Good afternoon, Mr. Hayden. Can you please tell the jury what you do for a living?
I'm a compliance, safety, and health officer for OSHA.
What is OSHA?
It's the Occupational Safety and Health Administration.
What exactly does OSHA do?
So basically, we're a federal agency that is there to make sure that workplaces are safe. So we provide information, trainings, and other such assistance to employers.
Does OSHA also inspect workplaces to make sure they comply with your standards?
They do, yes.
And how long have you worked for OSHA?
It's been about 13 years now.
And where did you go to college?
I went to Texas State Technical College.
What degrees did you receive from Texas Tech?
So I got 2 degrees from them, actually. I got a degree in environmental technology compliance, and then I got another degree in occupational safety and technology compliance.
Can you explain to us what those degrees mean?
Yeah, so basically these 2 degrees are the degrees that you would want to get if you're going to work for OSHA. And so it's more of a training program to help you get more familiar with workplace hazards and environmental hazards and whatnot, so you can inspect that at a workplace.
And as a compliance, safety, and health officer, what exactly do you do at OSHA?
So my job at OSHA is pretty great. I get to travel a lot, and I go to all these work sites and inspect whether or not that they are up to code.
Now, were you in the courtroom a few moments ago when the plaintiff's witness, Kelly Danes, said she's performed 60 workplace investigations in her career?
I was, yes.
In your 13 years at OSHA, how many inspections have you done?
Thousands, I'd say, probably.
In those thousands of investigations, were they all focused on OSHA regulations?
Yeah, that's what I'm looking for.
So now I want to turn to your role in this case. Why are you here testifying today?
I was subpoenaed by you to testify.
Are we paying you for your testimony today?
No, ma'am.
Is anyone paying you for your testimony?
No, ma'am.
So how did you become involved in this case?
So I performed an inspection on the Chimes department store back in 2018.
I want to talk a bit more about that inspection. What did you do to investigate the space?
So just like any of my other investigations, I get to the workplace and take a look around and see if there's any thing that stands out as dangerous or in violation of a regulation.
Now, without telling us what those opinions are, after you inspected the space, were you able to reach any opinions to a reasonable degree of professional certainty?
Yes, I was.
When formulating those opinions, did you rely on the principles and methods generally used in your field?
Yes, ma'am.
Did you apply those principles and methods to the facts in this case?
I did.
Your Honor, in accordance with Federal Rule of Evidence 702, we tender Perry Hayden as an expert in workplace safety with a focus on OSHA regulations.
Any objection?
No objection.
There being no objection, he shall be tendered as an expert on those topics. You may proceed.
Now, Mr. Hayden, during your investigation, did you specifically look at the area behind Chimes department stores?
I did.
Did you form any opinions as to whether that area violated any OSHA regulations?
I did.
In your expert opinion, did it violate any OSHA regulations?
No.
Were you in the courtroom earlier when Ms. Dane spoke about the things she identified as being dangerous in that area?
Yes.
Now, if you see anything that's dangerous when you inspect an area, do you issue a citation?
Not necessarily. There's always going to be some hazards to the workplace that are unavoidable. I issue citations if there's a violation of the regulation.
In your professional opinion, as an OSHA inspector, how would you characterize the issues that Kelly Danes was calling dangerous?
Just natural hazards of the workplace.
Did they warrant citations in your opinion?
No.
Can you tell us why?
Yeah, so primarily because this area is a loading dock. And so a lot of what Ms. Danes identified as being dangerous does not actually accurately reflect about what we look for with a loading dock. And so there's not going to be guardrails with the loading dock or other such things.
Now, why does there being no guardrails on a loading dock not create OSHA violation issues?
Well, because if you had a railing on the loading dock, you couldn't very well unload or load things from a truck to the store. And so it'd defeat the whole purpose.
So based on that, do OSHA regulations require loading docks to have guardrails?
No.
And is that why you didn't find that the issues that Kelly Danes discussed actually warranted issuing any citations?
Yes.
Now, if that loading dock were used for other things besides accepting deliveries, would guardrails be required then?
No, ma'am. It's still a loading dock. You know, if I took my sandwich there and ate on the loading dock, it wouldn't become a diner. You know, if kids were skating in the parking lot, it doesn't turn that parking lot into a skate park. It's still a parking lot. And in this case, a loading dock is still a loading dock.
Now, does that remain true even if people are using that loading dock to throw out trash?
Yes.
What about if they're going out there to smoke a cigarette?
Yeah, it's still a loading dock.
Now, what about the fact that this loading dock had stairs?
That doesn't change it at all. It's still a loading dock. That's still where they're backing up the truck to the back of the store, taking off the goods from the truck and bring them into the store.
And Mr. Hayden, what about all those regulations that Kelly Danes talked about in her direct examination?
What she was referencing to wasn't specific to loading docks.
Do any of those OSHA regulations apply to loading docks?
No.
Thank you, Mr. Hayden. Pass the witness, Your Honor.
Thank you, counsel. Plaintiff's counsel.
Good morning or maybe afternoon where you are, Mr. Hayden.
Good morning.
Part of your job is to make sure that workplaces are safe, right?
Yes,
Specifically, you inspect workplaces.
I do.
Your job is to help employers make their workplaces safer.
Yes,
You can recommend steps for them to follow to make their workplaces safer.
I can. Yeah.
Sometimes those steps are really simple, aren't they?
Depending on the circumstances, it could be.
Sometimes they are, though.
Sometimes.
You inspected the defendant's store back in 2018.
Yes, ma'am.
You were looking for any condition that might be dangerous to the employees.
Yes, and any rule violations.
That's right, because a condition that violates an OSHA rule, that could be dangerous to the employees.
It could be, yes.
I want to be clear about this. You look for violations of OSHA regulations.
Yes, ma'am.
You know that OSHA regulations aren't the only regulations that apply to workplaces.
Correct.
You don't look for violations of, say, the International Building Code when you're doing an inspection.
No, ma'am. I'm an OSHA inspector.
That's right. In fact, you don't have any opinions about whether or not that area violated parts of the IBC, do you?
No, ma'am.
I want to talk about who controlled that back area. During an inspection, you asked a manager to show you all the places on the premises where employees worked.
Yes.
One of the places that that manager said employees worked was the area behind the store.
Yes.
In fact, the manager said employees regularly worked back there.
That sounds about right, yeah.
In fact, based on your inspection of that property, it seemed to you like that back area was the defendant's property. Is that right?
It could be. That's kind of out of my expertise, but it could have been.
It seemed to you like it could be.
Yeah, it could be.
It seemed to you like at least they were in control of it, right?
It could be, yeah. I'm not entirely sure, but definitely could have been.
That's how it seemed to you. That's a yes.
Yeah, that's how it seemed.
Well, let's talk about the inspection you did in that back area. When you first went out there, you'd say you were pretty alarmed, weren't you?
Yeah, my initial gut reaction, yeah.
There were obvious issues.
Yeah, before I knew what that back area was, yes.
I'm going to show you Exhibit 19. Some of those obvious issues was that there was no guardrail, right?
Yes, when I thought that these were just some stairs going inside of the building, yes.
And when you first looked at these stairs, that was what you thought they were, just stairs going inside the building.
Correct. I didn't know that it was a loading dock before I did my full inspection.
We'll come back to that in just a moment, but I'm going to show you Exhibit 3. One of the other obvious issues you spotted was that the concrete was cracked. Is that right?
Yeah, on the edges there was some cracking of the concrete.
Okay, thank you, Ms. Smith. So you notice the missing guardrail, the cracked concrete, you're alarmed, but then you talk to a manager, isn't that true?
Yes, that's part of the investigative process.
The manager says, well, we use this area as a loading dock.
Yes.
You hear that and you decide not to write them any citations.
Correct, because there is no violation of the rules.
Because in your opinion, OSHA doesn't require guardrails around loading docks.
That's not just my opinion, ma'am. That's what the rules are.
Sure. Let's say for a moment that OSHA doesn't require guardrails around loading docks. You'd agree with me that does not fix that cracked concrete you saw.
I'm a little confused by your question. So you're saying if OSHA, so setting aside the guardrail issue, there would still be some concerns about the cracks in the cement?
That is exactly right. The regulations about guardrails around loading docks, that does not fix that cracked concrete you said was an obvious issue. Is that right?
That is correct.
You didn't issue a citation for that concrete.
No.
Now, we've heard this area was used as a loading dock, but you know it wasn't used only as a loading dock.
No, I think they took out some trash occasionally and took some smoke breaks out there.
And you told us a few moments ago that eating a sandwich somewhere doesn't make it a diner. Is that right?
Right, ma'am.
But you know that this wasn't designed to be a loading dock to begin with, was it?
Yeah, I'm not entirely sure. Excuse me. I'm not entirely sure how the building was designed when it was first made.
You could tell that there used to be a railing there, though.
Yeah.
Loading docks don't have railings.
No.
So it wasn't designed to be a loading dock.
Maybe when the building was first designed, it might not have been.
So by your logic, if eating a sandwich somewhere doesn't make it a diner, calling something that wasn't designed a loading dock doesn't make it one, does it?
No, but using a loading dock consistently as a loading dock would make it a loading dock.
Designed that way, just calling it that, it doesn't make it one. That's a yes?
Just calling something doesn't make it something, sure.
I want to talk about something else that you checked for on that visit. You always check to make sure that exits are well lit, right?
Yes.
That's because there is an OSHA regulation that requires it.
Yes.
If a workplace has an exit that is not well lit, that could be a violation.
It could be.
Now, you did your inspection of the defendant's store during the daytime.
Yes.
You noticed there was a light on the outside of the building.
There was, yeah.
You didn't see that light turned on at any point during your visit.
No, it was during the day.
Mr. Hayden, you've been here in the courtroom for the whole trial today, is that right?
Yes.
You heard Ms. Gilmore's testimony, Mr. Gilmore's testimony, excuse me.
I did.
You heard him testify that he told the managers, that several employees told the managers that that light couldn't be turned on. You heard that?
That sounds about right.
During your inspection of the defendant's property, that is not what a manager told you, is it?
No.
The defendant's manager told you that that light was on every time an employee went outside.
Correct.
Your decision not to issue a citation was based on that.
Yeah.
Mr. Hayden, if you had found out that that light was never on when employees went outside, would you have issued a citation?
Possibly. I'd have to look at some of the other factors, if there's any other lighting in the area, but it certainly would have been a consideration.
Certainly would have been possible if you'd had all the information that you might have issued a citation.
It could have been possible.
I want to talk about why your inspection might have gone the way it did. You'd agree with me that you interpret OSHA regulations more narrowly than other inspectors, don't you?
I tend to, yes.
You issue fewer citations, in fact, than any other inspector in Central Texas.
I believe that's correct, yeah.
Objection. Your Honor, if counsel's getting into this under 703, then they have to show that its helpfulness to the jury in evaluating Mr. Hayden's opinion substantially outweighs any prejudicial effect it may have. As this is hearsay, we argue that counsel has not met this burden and therefore it should still be precluded.
There's no pending question. You may make that objection to a pending question. Ms. Forster, proceed.
Mr. Hayden, you know you're more lenient than other inspectors.
Yeah.
Thank you. Pass the witness.
Any redirect?
Yes, Your Honor.
You may proceed.
Mr. Hayden, you were asked a lot of questions about how this loading dock was designed.
Mm-hmm.
What made this a loading dock?
Well, it made it a loading dock that the current occupants of that building, Chimes Department Store, used it and designated it as a loading dock. That's where they would get their shipments in. That's where they would unload their products and bring them into the store. And so that consistent use, that designation, that's what makes it a loading dock.
Thank you, Mr. Hayden. No further questions for this witness, Your Honor.
You may the witness be excused. All right, thank you very much. You may be excused at this time. You may call your next witness.
Yes, Your Honor. At this time, the defense calls Reese Geller to the stand.
Mr. Geller, thank you for joining us. Sir, if I might ask you to please raise your right hand to the best of your ability. Sir, do you solemnly swear that the testimony you shall give in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If I might ask, sir, at this time for you to please state your full name for the record as well as spell it.
Reese Geller, R-E-E-S-E, Geller, G-E-L-L-A-R, E-R.
Counsel, you may proceed.
Yes, Your Honor. Good afternoon, Mr. Geller.
Good afternoon.
Can you please tell the jury a little bit about yourself?
My name is Reese Geller. As indicated, I am the owner of Chimes Department Store. I live here in Waco, of course, married, have 3 kids, and I am here today to help however I might.
Mr. Geller, you said you own Chimes Department Store. Can you tell us a bit about the business?
The business, as you say, is a department store. We sell a little bit of everything. I suppose it would be good to perhaps compare it to a J.C. Penney's or maybe a Macy's, but it's on a smaller scale being here in Waco. We sell a bit of everything: clothing, hardware, appliances, and the like.
Are you a family-run business?
Yes, we are. In fact, I am the 3rd generation in the family business. Chimes was begun by my grandparents, and then eventually my father, my parents took over the operation of it. And I have been, however, the owner and operator since 2010.
And how long have you worked at Chimes Department Store overall?
I think forever, nearly. I started when I got out of college in 1998. And under the influence of the family, I began, I guess you might say, at the bottom of the ladder. I was in the buying department, dealing with matters of purchases of inventory and the like. And I eventually worked my way up to become, as I indicated, the owner and the operator now.
And where is the store located?
It's located on Bosque Boulevard. 2005 is the address on Bosque.
Now, I want to talk a bit more about that location. Are you leasing that space on Bosque Boulevard?
Yes, ma'am, we are.
Are you familiar with that lease?
Yes, I am. The lease was negotiated by my father with Kermit Realty. My father was the principal negotiator. However, I was involved in various aspects of the development of the lease agreement.
Now, Mr. Geller, I'm showing you what's already in evidence as Exhibit 11. Is this that lease?
Yes, ma'am, it is.
And who's the landlord on this lease?
Kermit Realty,
And who's the tenant?
Chimes.
We're going to go now to section 1.10. Can you describe what the demised premises is for us?
The demised premises are the part of the premises, the overall premises that are under lease to Chimes.
And how does this section of the lease specifically define demised premises?
Would you like me to read it?
Yes, please, Mr. Geller.
The demised premises are defined as follows: approximately 18,000 square feet of space in the shopping center, and being the space cross-hatched on the site plan, which shall have a minimum of 100 feet of clear interior width.
Now, you just mentioned a site plan. I'm showing you what's already in evidence as Exhibit 12. Is this that site plan?
Yes, ma'am, it is.
I'm outlining an area here in blue. Does this include the cross-hatched area?
Yes, ma'am, it does.
So according to the lease, is this the demised premises?
Yes, ma'am.
Now, the landing and stairs at issue here today, are they inside of that blue area?
No, ma'am, they are not.
Where are they located?
Well, in the site plan, they're up at the top of the plan, and they are located by the marking of a red X.
Your Honor, I now move to preserve this as demonstrative Exhibit 12A to be used in closings.
Any objection?
None.
There being none, it shall be preserved. You may proceed.
Now, Mr. Geller, because that loading dock is located outside of that blue shaded area, was it under Chimes's control?
No, ma'am, it was not.
Who was responsible for that area?
Kermit Realty, the lessor.
Now, did your employees use that area at all?
Yes, they did from time to time.
What would they use it for?
Well, we don't want our employees smoking in the store, of course, for, I think, very apparent reasons. We run a nice operation, and so we ask our employees to please go out the back onto the loading dock area and the like, so they would be smoking outside of the store premises.
Now, were employees from other stores in the shopping center allowed to use this loading dock as well?
It's a common area, yes, ma'am.
What do you mean by a common area?
Well, it's not under lease to Chimes. It is an area, when I refer to common, that is usable by all of the tenants in the entire developed building complex.
And according to your lease, who's responsible for maintaining common areas?
It would, of course, be the landlord, Kermit Realty.
I want to go back to that lease for a minute, Mr. Geller. I'm showing you section 6.3. Can you please read for us what this says?
The title is Maintenance of Common Area. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area. And landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
Mr. Geller, where was the plaintiff when he was injured?
He was on the loading dock on the stairs leading upward to the base of the loading dock.
So according to your lease, who was responsible for making any changes to that area, should they have been necessary?
As I've indicated, it would be, of course, Kermit Realty. They are the landlord, and the loading dock is not part of the space that is leased to us, not part of what the release refers to as the demised space.
Now, Mr. Geller, I want to focus very specifically on this loading dock for just a moment. We've heard some witnesses claim today that that back area isn't a loading dock. So as the store owner, what was that space behind your store?
Well, that's quite incorrect. It's a loading dock. We use it to bring in our shipments, to outship inventory that's being returned to the vendors, manufacturers, distributors, and so forth. We have a loading dock. It's available for that purpose. It's in common area, but it is certainly a loading dock.
And how long have you been using it as a loading dock?
We've been using it for a long time. In fact, my father made the request that the railing that originally was on the loading dock be removed because it was inconsistent with it being used as a loading dock. But since that time of the removal, our use of it has unquestionably been as a loading dock.
Now,
And I might add too that, of course, the railing would not have been consistent with the being a loading dock.
why wouldn't a railing be consistent with that?
Well, trucks back up to offload and to onload, and we sell, as I noted, many items. Even clothing can come in very large boxes, and you need to have clearance between the back of the delivery truck and the doors leading into the building. And so the railing would simply be an impediment to its use.
Now, is this loading dock also used for other purposes?
Not by us. It's a loading dock.
Just to clarify, Mr. Geller, do your employees also use that area to take out the trash?
Well, yes, we have a dumpster that we have placed adjacent to the loading dock. And as I've already indicated too, our employees are asked to go to that area behind the store when they want to smoke.
Now, does your lease indicate who's responsible for loading areas?
Yes, it unquestionably specifically designates loading areas as being part of the common area, which is to be maintained, operated, and the like by the landlord, the lessor, as indicated here being Kermit Realty.
I want to go over exactly where your lease says that. I'm showing you section 6.1. Can you tell us what the title of this section is?
The title is Use and Regulation of Common Area.
And can you read this section through the phrase lighting facilities?
Yes, ma'am. The term common area, which is in quotes, is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including among other facilities, such as may be applicable to the shopping center, parking areas, private streets and alleys, landscaping, curbs, loading areas, sidewalks, malls, and promenades, and also lighting facilities and incomplete but drinking.
Thank you, Mr. Geller. Now, do you consider your loading dock to be a loading area under this section?
Yeah, yes, of course, it fits the definition of a loading dock, and the lease says loading areas. There's really no inconsistency at all. It's a perfect fit.
And do you consider the lighting located above that loading dock to be a lighting facility under this section?
Yes, ma'am, I do. Mm-hmm.
So according to section 6.1, who was responsible for the loading area and the lighting facility?
Well, once again, it would be Kermit Realty, the landlord, the lessor.
Now, were you in the courtroom earlier when Mr. Hayden said that while he didn't issue any OSHA citations, he did see some issues during his inspection?
Yes, ma'am.
If he had issued any citations, would you have done something to address them?
No, it would have been the obligation of the landlord, Kermit Realty, to do so.
So would you have alerted the landlord to those issues?
Well, sure. We knew that there was something unreasonably dangerous, or that was a, excuse me, that was a safety matter. We would notify Kermit Realty and ask them to please do what they are obligated to do under the lease.
Finally, Mr. Geller, I want to talk briefly about the plaintiff's conduct. Did Chimes make the plaintiff take a smoke break on January 23rd?
No, we don't make our employees take a smoke break. We tell them that if they're going to take a smoking break, that they should please do it outside in the common area on the dock.
Did you hear the plaintiff say earlier that he sometimes smokes in his car while he's at work?
Yes, ma'am. Mhm.
If he had wanted to do that on January 23rd, would Chimes have stopped him from doing so?
Of course not. He's free to be in his car. Our only concern was that smoking not occur in the store.
And did Chimes force him to go around that half open door on the loading dock?
Heavens no.
Thank you, Mr. Geller. Pass the witness, Your Honor.
Thank you. Plaintiff, you may proceed.
Your Honor, before I do that, can I request a brief sidebar?
You may. Counsel, please approach.
There are two issues that we discussed in pretrial motions that I expect to come up on this cross-examination. I'm happy to take those up when they come up on the cross-examination, but I thought for convenience, it might make sense to deal with them both now.
Why don't you alert me to the potential issues?
Sure. One of them is that we do plan to cross-examine this witness on the control and feasibility of whether or not he could have, or whether or not he did install a light switch to work, to make the outside light work. We're going to do that because we believe that the defendant has opened the door by contesting control today. That's the first one.
All right.
The second one, Your Honor, is that we do plan to offer Exhibit 14, which is that incident report from the prior incident from 2010. That is admissible because there are hearsay exceptions or exemptions for every part and every layer of the hearsay in that document.
I think where we are at this juncture, we should proceed with the examination, and if and when time comes for counsel to make an objection or for you to move to admit the relevant exhibit, you may do so at that time. I still don't think we're far enough along for me to make those determinations at this juncture. So let's go ahead and proceed with cross-examination at this time.
Sounds good. Hello to you, Mr. Geller.
Hello, how are you doing?
I'm doing great. Thanks for asking. You are the owner of Chimes Department Store.
Yes, ma'am, I am.
You take pride in your business.
Yes, of course. It is a family business, and we've invested a lot in it, and we're very proud of what we have done for the community.
So you take pride in your business.
Yes, ma'am.
You care about your employees, yes?
Of course.
You'd take any steps you could to keep your employees safe.
Any steps within the purview of our being the owner of the premises, yes.
If there were simple steps you could take to keep your employees safe, you would take them, wouldn't you?
Yes, for instance, as was noted, if there would be a problem we would see on the loading dock, we would call Kermit Realty as the landlord and ask them to please take the corrective action that they are responsible for taking under the lease.
That's a yes. If there were simple steps you could take, you would take them.
Yes, including calling Kermit.
I want to talk about the area behind your store. I want to talk about who had control of that area.
Yes,
You'll agree with me, it was the defendant who requested that the railing be removed from that landing, right?
Yes, ma'am. It was my father, Richard, a long time ago requested that so we could use it as a loading dock.
That's right. It was the defendant who used that landing as a loading dock.
Yes, ma'am. We use it regularly, sometimes just about every day of the week, deliveries coming and going.
That's a yes.
Yes, ma'am.
It's the defendant who added a dumpster back there.
Yes, ma'am. We requested, my father requested that the we didn't ask permission for the dumpster to be placed there, if that's what you're asking.
It was the defendant who put a dumpster back there. Yes or no?
Well, the defendant chimes, yes, we put a dumpster there. We
that's a
didn't
yes
ask
to my
permission,
question.
though, because though it did not impair any use of the common area.
That's a yes to my question.
Yes, ma'am.
Now, you told us a few moments ago that you believe it is the landlord who's responsible for that area. Is that right?
Yes, ma'am.
Mr. Geller, you know that your landlord doesn't clean that area?
Clean the area. I'm not sure what they do we ask our employees if they see some trash out there and the like, to make sure that it's kept presentable. As to what Kermit does, I do not know. It is their responsibility, of course, because it's a common area.
Is it your testimony that you don't know whether your landlord doesn't clean that area?
It's a common area and it can be used for any purpose. We don't have a camera on the area. We're not monitoring it. It's simply a loading dock.
Mr. Geller, can I take that as a no, that you don't know whether or not they clean that area?
No, I don't. It's a common area. I hope that if they would find something, that they would take care of it because of it being their obligation, of course.
Your
We're
Honor,
glad
at this
to help
time,
with small stuff, like I said, if there's a piece of trash or cigarette butts or the like, our employees are told to come on, make this look clean and presentable. We're proud of what we do here.
Mr. Geller, thank you. And I didn't mean to interrupt you there. Your Honor, I'm going to request a sidebar about a different issue at this time, actually.
Counselor, if you'll please approach.
Pursuant again to pretrial motions, Ms. McQuiggan made an objection to or moved to exclude Exhibit 40, and I said that I would be using it if necessary for impeachment. I just asked the witness if he knew that the landlord didn't clean that area. He did not answer my question clearly, certainly didn't say that he knows they don't clean that area. I'd like to use Exhibit 40 for impeachment at this time.
I would ask for you, Ms. Forster, to please ask the question again of the witness more clearly. And if at that time you still feel the necessity to renew this objection, you may do so at that time.
Will do. Mr. Geller, I'm going to ask you for just a yes or a no on this question, if that's okay.
I'll try.
I appreciate that. You know that your landlord does not clean that back area.
I know, I guess you could say, I'm sorry, I'm going further, but the point I'm saying is that they may clean the area. I hope that they do. I hope they do the same thing that we would do if we saw that there was something trashy or awry with the appearance.
I'm sorry, Your Honor. At this time, I'm going to have to ask either that you instruct the witness to answer the question or that I can impeach.
If you'll show me again, counsel, please approach and show me again the text of the email.
We'll go ahead and enlarge part of that so it's easier for you. Ms. Smith, if you want to go ahead and highlight the relevant line, we don't clean that area. This is written by the landlord.
May I respond, Your Honor?
I'm going to ask Ms. McQuiggan if you'll read again the deposition testimony that you referenced earlier during pretrial.
Yes, Your Honor, just one moment. I apologize, Your Honor. Okay, it's on page 13 of Mr. Geller's deposition. Line 3, question, is Exhibit 40 a true and correct copy of that email? Yes, it is. What do you have to say about this email? Well, he can say whatever he wants. Kind of sounds like the rantings of a crazy person to me, but he should go read the lease because I think the language in the lease is very clear. But do you dispute any of his claims in this email? No, but it doesn't matter. We have a lease and they should live up to it. Additionally, Your Honor, we would add that this email was sent specifically in regards to this litigation. So the landlord saying that they don't clean that area cannot be relied upon because they are trying to abrogate responsibility.
Can I respond to that briefly?
You may, Ms. Forster.
It can be relied upon because Mr. Geller told us in his deposition it could be. He was asked if he disputed any of these claims and he said no.
Upon consideration of the arguments, counsel, that each of you have made, I'm going to go ahead and overrule the objection as it relates to, and I will not permit this exhibit to be used in connection with the witness's testimony. So Ms. Forster, you may proceed with your examination.
I want to make sure I understand. You're overruling the defense's objection.
Sorry, I'm overruling your objection to the witness's non-responsiveness and a request to use the exhibit. I apologize if I was unclear.
Okay, so I'm just going to clarify one more time. I cannot use that exhibit. Is that right?
Correct.
Understood. I'll move on.
Thank you.
Mr. Geller, yes or no, you personally had never seen your landlord clean that back area, yes?
No, I have not. As I say, it's a loading dock. It's not the type of place that I often find myself. And I'm certainly not looking for people to come by the loading dock for any purpose at all. We just use it for our trucks, our vendor
That's a
trucks.
yes.
Yes,
That's a
ma'am.
yes to my question.
Yes, ma'am.
You personally had never seen anyone from your landlord in that back area. Yes or no, please?
No, I have not.
I want to talk about the conditions in that back area. I'm going to show you Exhibit 3. It's already in evidence. Now, this is a photo taken from the top of that landing, right?
Yes, ma'am.
We can see here, I'm going to circle in red, a hole in the top step.
Yeah, yes, ma'am, as a whole.
See a hole in the bottom step.
Yes, ma'am. Mhm.
You know that's where that railing used to be.
Yes, ma'am.
You didn't patch these holes, did you?
No, ma'am, it would not be our responsibility.
Sure, you didn't ask your landlord to patch those holes.
No, ma'am, it is a responsibility of Kermit Realty.
You didn't ask them to do it.
No, ma'am.
I want to talk about another condition in that area, the lighting. There was an outdoor light, isn't that true?
Yes, ma'am.
But you knew that employees could never use that light, could they?
Yes, they could not use it because we didn't have a switch to the light. We didn't control it. The switch is in a leased space by another tenant.
I want to make sure I heard you right. You just said you didn't control that light switch. Is that true?
Well, there's no light switch to control. The light switch is in another tenant's premises. So it's not a matter of we didn't, it's a matter that we can't control something that is not on our demised premises, in our store, I should say.
You'd agree with me, though, that you could add that light switch inside your store.
Yes, ma'am, we could have a switch inside. It would be something that could be done.
You had control over that.
If there were a light switch that was inside the store, that's the difference between I'll use the language from the lease, the demised premises and that which is not part of the demised premises.
What I'm saying is the fact that there wasn't a light switch inside that store, you could have added a light switch inside that store. That was in your control. That's a yes?
Yes, we could have added a light switch. However, the light on the dock, that's for Kermit to take care of. I'm talking hypothetically here. It's a matter of Kermit making sure that things are as they need to be on the loading dock because it's
You didn't install a light switch inside your store for that light before January 23rd.
No, ma'am. Mm-mm.
At this time, plaintiff requests another sidebar, and I apologize, Your Honor.
Counsel, please approach.
At this time, we do plan to offer Exhibit 14 into evidence. I'm happy to discuss the hearsay in that document more specifically.
You're referencing the recorded statement?
That's right.
have you established that this witness has knowledge of that or the knowledge of the exhibit?
I can do that now, Your Honor.
Let's please do that first.
Okay. Mr. Geller, you know that another employee was actually heard on those steps before Mr. Gilmore, right?
Yes, ma'am. It was about 10 years or so ago.
You know that your company wrote up a report of that incident.
Yes, ma'am. Yes.
You've seen that report.
Yes, ma'am.
Sidebar at this time.
Please approach. Yes, Ms. Forster.
I'm happy to discuss the hearsay issues. If you want to see the document, you let me know what Your Honor wants.
So Ms. Forster, I believe what you're asking for at this time again is to admit having laid the foundation, the exhibit 14. Let me go ahead and ask Ms. McQuiggan, do you have any objections to exhibit 14's admission?
Yes, Your Honor, that there are still hearsay issues here that have not been cured. This document consists primarily of statements from that employee that were recorded in this document. We need to hear additional foundation to show that those are admissible under some hearsay exception, and we have not heard that yet.
And Ms.
Your Honor.
McQuiggan, specifically, can you, or be more specific regarding your hearsay concerns?
Yes, Your Honor, my hearsay concerns are specifically to the portions of the document that that are transcriptions of statements made by the employee in question who was injured. If you'll forgive me, Your Honor, I'm trying to find so I can give you more exact quotations, but primarily there is a large paragraph on the first page of Exhibit 14 under the section accident loss that is the employee's description of the accident in question. That is all hearsay for which we have not heard an exception.
Ms. Forster, your response.
Yes, I'll start, Your Honor, by noting that Federal Rule 104A is clear that on questions of admissibility, Your Honor can consider evidence that isn't admissible or that hasn't come in yet. So it's not necessary for me to lay the foundation for the hearsay exceptions with the witness under 104A. Now, the exceptions here, and pardon me, there are two layers of hearsay, so I'm going to be particular about this. The first layer of hearsay, this document was prepared by the defendant company. It's admissible as a party opponent statement under 801D2. Second, there are statements within this document of both the manager, April Nardini, that's an employee of the defendant, again covered under 801D2. There are also statements in here of Jason Stiles. These statements are admissible under two separate and independent bases. Number one, those statements are admissible because Mr. Stiles was also an employee of the defendant under 801D2D. And then secondly, they are admissible for notice to show that the defendant knew of the risks and didn't do anything about it. That is directly tied to what we have to prove in this case today.
All right, and any response by defense counsel?
Yes, Your Honor, as to the statements made by the employee, Jason Stiles, 801D2D requires that the statements be made in the course of the employment on a matter that concerns that employment. Him providing an account of an accident that he had while he was outside is not part of his employment. We don't know what his job was for Chimes Department Store. We don't know specifically what he was doing when he was out there. So counsel has not laid that sufficient foundation so as to allow an exception for the statements here by Jason Stiles. Furthermore, Your Honor, the fact that this document was made by the defendant, by my client, does not in and of itself cure the hearsay issues. The portions that have to do with what happened to Mr. Stiles, those are still hearsay because the person who made this document only knows about them because Mr. Stiles told them. So the hearsay here still has not been cured.
All right, any further response, Ms. Forster, before I make a ruling?
Yes, Your Honor. What I'll say about that is that 801D2D requires that statements be made by a party's agent or employee on a matter within the scope of the relationship and while it existed. The fact that Mr. Stiles, that employee, made these statements to his employer as part of this incident report that his employer was collecting, that is within the scope of that relationship. It's covered under 801D.
The court's going to overrule the hearsay objections and allow Exhibit 14 to be admitted. I find that counsel has laid foundation that this witness is familiar with the document, and this time, Ms. Forster, you may proceed.
Thank you. Mr. Geller, I'm going to show you Exhibit 14. I'm going to zoom in on part of this so it's easier for you to see. We're going to highlight starting from as I was walking down the steps. I'm going to read this aloud. As I was walking down the steps, I slipped on what I think was loose concrete, and I fell face first onto the ground at the bottom of the steps. Mr. Geller, after this incident report, you didn't make any effort to clean up loose concrete on those steps, did you?
No, ma'am, because it's the common area controlled by Geller, or excuse me, controlled by the landlord.
You didn't make any effort.
No, because it was not our responsibility. It was the responsibility of Kermit Realty, the landlord.
You've said that a few times, and so I do want to talk about it. At the beginning of when I started asking you questions, you told me you care about your employees, right?
Yes, ma'am.
If you could take a simple step to make them safer, you would do it even if it wasn't your legal responsibility, right?
That's right. I would have us call Kermit Realty to take care of any problem on the dock.
After this incident report, you did not call Kermit Realty to clean up that loose concrete, yes or no?
Well, we're not obligated to call because it's common area, but typically if we saw any type of safety issue, we're not in the business of being able to identify safety issues, of course. But if we did see a safety issue, we would have the option, certainly, of calling up the landlord.
Mr. Geller, which is it? Do you only do what you're obligated to do, or do you do what keeps your employees safe?
Objection, relevance in 403, Your Honor.
Overruled.
Mr. Geller, which is it? I'll repeat the question. Do you only do what you're obligated to do, or do you do what keeps your employees safe?
Well, we only do what we're obligated to do, and hopefully that is concurrent with what is best for our employees. That's why we would call Kermit if we had a concern.
Nothing further, Your Honor.
Thank you, Ms. Forster. Ms. McQuiggan, anything further for your witness?
Yes, Your Honor.
Thank you. All right. May this witness be excused?
Yes, Your Honor.
Thank you so very much for joining us. You are.
Thank you, Your Honor. Thank you.
To confirm, does defendant have any further witnesses to present or evidence to proffer to the court at this time?
Your Honor, at this time, the defense rests.
Now let's go ahead and turn following closing of evidence to discuss the charge. We are going to be having a charge conference. Have the parties agreed on the version of the charge that will be used during closing arguments, or does the court need to entertain an argument?
Your Honor, we have notified opposing counsel as to which charge we intend to bring. However, we have not reached any agreement before trial here today.
All right, so let me go ahead and ask at this time, plaintiff's counsel, your thoughts on the charge that defense counsel requests to use.
Yes, Your Honor, we are going to object to that charge, and specifically, we're going to move for a judgment as a matter of law against the defendant's affirmative defense about the landlord's control. Happy to explain why.
Please proceed.
One of the elements that is on that jury charge that the defendant would have had to prove is that, and sorry, let me just pull up the language here, Your Honor, is that Kermit Realty Group knew or reasonably should have known of the danger. We have heard not a single piece of testimony that would have shown that the landlord knew or should have known of the danger. In fact, we've heard testimony in the opposite direction. There simply is not a basis here, even viewing the evidence in the light most favorable to the non-moving party, to find that a reasonable juror could conclude that Kermit Realty Group did know or reasonably should have known.
Any response?
Yes, Your Honor. Viewing the evidence in the light most favorable to the non-moving party, here the defense, we have made a showing on which a juror could find that the landlord, Kermit Realty LLC, was responsible for that loading dock, specifically that they controlled that loading dock, and therefore it was their responsibility to find, identify, and subsequently fix any safety issues that may have arisen, simply by virtue of the fact that they controlled it. Your Honor, today we showed you Chimes Department Stores is leased with Kermit Realty. We showed you that the loading dock is outside of the demised premises on that lease, and we've heard many times here today that that loading dock existed in a common area that was accessible to all tenants. And the fact that Chimes Department Stores is the primary user of that space is merely circumstantial and is not sufficient to establish control. Therefore, Your Honor, this is clearly a question of fact that should go to the jury, and Kermit Realty LLC should be included in the charges.
So as it relates to the motion made by plaintiff's counsel, the court's going to deny that. Let's go ahead and channel our efforts back into determining what will be our final charge. I have each of the 4 versions in front of me. If I can go ahead and ask this quick again, I know you've advised that you've told plaintiff's counsel which version you're requesting. Can you advise me which version and perhaps identify in the question so that I can determine which one you're actually looking at?
Yes, Your Honor, we intend to use the first version of the jury sheet, which as to questions both 1 and 2, list the plaintiff, Chimes Department Store, and Kermit Realty LLC.
Okay, I believe I have that version. Can I, again, I'll hear argument from you briefly as to why this is the charge that you request, and then plaintiff's counsel, I'll hear from you in response.
Yes, Your Honor, we are requesting this charge because we have made a sufficient showing by which a reasonable juror could find by a preponderance of the evidence. First, as I've already discussed, that Kermit Realty was responsible for this space, and therefore should any negligence in maintaining that space be proven, the responsibility therefore would fall to Kermit and not to Chimes Department Stores. That is based on the lease and the demised premises and it being a common area as we just discussed. Additionally, Your Honor, through my cross-examination of the plaintiff and subsequent questions of Reese Geller, we've established that Jordan Gilmore himself made certain choices that night that were a failure to exercise ordinary prudence, and thereby he bears at least some responsibility for the injuries that he incurred. He was on a landing and a set of stairs that he's used thousands of times in the past. He had other choices that he could have made, and his failure to do so contributed to his being injured. Therefore, Your Honor, the jury should be able to consider all 3 of these parties and how they are responsible for what happened here and in what proportions. And therefore, we are requesting that all 3 parties be listed on the jury sheet.
Thank you. Ms. Forster, your response?
Yes, Your Honor, I could repeat my arguments about my Rule 50 motion about Kermit Realty Group, but I assume that Your Honor would prefer that I do not, and so I have no other objections.
Okay, since there being none, we will go ahead and proceed with use of that charge for closing arguments. Ladies, let me go ahead and ask. We took a recess, obviously, during the break in the case in chief. The court is prepared for us to go ahead and press forward now with closings unless you would each request time in order to prepare. If you are requesting time to prepare, I'll give each of you a span of 3 minutes to do so. But if you don't need that time, I'm happy for us to go ahead and press forward. Ms. Forster?
Plaintiff would request that 3-minute time.
All right. In light of the fact that you're requesting that, we're going to go ahead and be in recess. My watch shows 12:26. So in 4 minutes time at exactly straight up 12:30, we will proceed. I'm going to go ahead and ask everyone, please don't stray from your videos. I don't think that's enough time for us to take a bathroom break. Just stay tight and let's go ahead and give y'all just a few minutes to get your cameras ready and get your notes prepared. Okay.
And may we have a time check, Your Honor?
You may. I have plaintiff has 14 minutes remaining, and I have the defense has 25.
Thank you, Your Honor.
Ms. Forster, are you going to be reserving any time for rebuttal?
I will be, Your Honor. Is it your preference that I pick a certain amount of time ahead of time?
It would be my preference, yes.
Okay. I'll go ahead and reserve 2 minutes.
All right. I'll note that 2 minutes is reserved for rebuttal, and I will give you a warning when you are coming up on those 2 minutes.
Understood.
Thank you. All right, if I can go ahead and have all of my judges, scoring judges, if y'all can turn your video on, let me know that you're back. Hello. And let's see, I see Matt. There we go, Tara. All right, so we've got all of our judges. We'll just wait for our participants to come back on and let us know that they're ready. And as soon as they are, we will proceed. Thank you. Y'all can turn your video off at this time. Ms. Forster, are you ready?
I am, Your Honor.
All right, reserving 2 minutes for rebuttal then. You may go ahead and proceed with your closing arguments. Thank you very much.
Simple steps. The defendant could have taken simple steps to keep its employees safe, but it didn't. Today you heard about the defendant Chimes department store. You heard about a store you might have been to, you might have visited. You heard about a place in that store you probably haven't seen. You heard about a back landing with peeling paint, crumbling concrete, a missing railing, a door that blocks the walkway. You heard at night there was no light. It's completely dark out there. You heard that the defendant could have taken simple steps to make that area safer, but they didn't. In that area, it was an accident waiting to happen. And on January 23rd, that accident did happen. You heard Mr. Gilmore say he went out that day to smoke a cigarette. He went down the stairs to follow the rules. And on his way back up, he's walking in the dark because the defendant hasn't fixed the light. He's trying to scoot around the door that's blocking the walkway. His coworker's trying to brace that door open so he can get any light that he can. He does his best. He takes a step. He falls. He lands on his right knee. That knee is shattered. You heard he had to get a full knee replacement. Folks, all of that could have been avoided if the defendant was willing to take just a few simple steps. Because they didn't, that's why we are here today. And you members of the jury, you are here today to answer one question. Did the defendant's negligence cause Mr. Gilmore's injuries? Now, it is the plaintiff who had the burden on this point. So it is the plaintiff who had to prove this. Now, the burden of proof in today's case was a preponderance of the evidence. We had to prove the elements of negligence were even just a little more likely than not. Let's look at those elements together. We had to prove to you, number one, that the defendant created an unreasonable risk of harm. Number two, that the defendant knew or reasonably should have known of the danger. And number three, the defendant failed to use ordinary care to protect its employees. I told you a moment ago, we had to prove to you each of these. We did. We're going to walk through them one by one and show you how. I'm going to start with that first one, unreasonable risk of harm. First of all, folks, you can use your common sense. It's pretty obvious. Very first thing I did at the start of this trial was make sure you saw those photos. The crumbling concrete, the missing railing, the holes in the corner of those steps. These are not hidden dangers. It doesn't take an expert to see the problems here. But in case you want one, we made sure you heard from an expert anyway. That expert came before you, Ms. Daines, you'll remember. She's been an engineer for, she said, 14 years now. She told you those stairs, that back area, it wasn't just dangerous, it was illegal. And it wasn't just illegal in one way or two ways, it was illegal in 3 ways. You saw these laws, folks. or you'll have these laws at least with you when you go back to deliberate. You will see that there are requirements about handrails, about illumination around exits. It just means make sure exits are lit up. Around door encroachment, it just means make sure the door isn't in the way of the walkway. I want you to go back, when you go back to deliberate, look at these laws. Think about what Ms. Daines told you. And think about why we have laws in the first place. What laws represent? A law is a consensus. It is something that the best, the brightest minds in our community sit down and work out together. It's something that we all agree on. We agree to follow those things because we think they'll make everyone safer. The defendant, they don't get to choose not to follow those. But that is exactly what they tried to do here. Now, defense counsel in a moment might quibble a bit. They might say, oh, well, this area was used as a loading dock, so maybe the railing doesn't apply. Folks, I want you to think back to my cross-examination of that OSHA inspector, Mr. Hayden. He told you, well, just because you eat a sandwich somewhere doesn't make it a diner. And I said, well, okay, just because you use something as a loading dock doesn't mean it is one. Just because you call something doesn't make it that thing. And he had to agree. And what you heard today was that area wasn't designed as a loading dock. It was designed to have a railing around it. The defendant just decided to take it out and call it what they want. But that doesn't remove their obligation. It doesn't change the law. Folks, think about this. Maybe they want to use that area as a loading dock, sure. But they can keep the railing on the stairs. Maybe they don't want the railing on the stairs for really big boxes. They can put a handrail on the other side. They can address any of the other issues in that area. They didn't do it. You heard what that area was like. We proved to you today that was an unreasonable risk of harm. Move on to the second element. We had to show you that they knew or should have known about the danger. First of all, folks, again, those photos are obvious. These are not hidden dangers. These are things you can see with your eyes. Their managers could see them with their eyes. But it's not just that we know that they should have known because it was obvious. We know they knew because they told us. Think back to Mr. Geller. Think back to Mr. Gilmore when he took the stand. He told you that he and several employees told the defendant's managers, that light doesn't come on. They said, oh, there's nothing we can do about it. He told you after he fell, what he did was run up to that, well, not run because he was injured, but first thing he did was go up to that manager and say to her, I just fell outside. And that manager said, we should have fixed those stairs a long time ago. We've told the owners about it, but I guess they have bigger problems to fix. Sorry about that. He shattered his knee, and his manager said, sorry about that. They knew, and we proved it. Let's talk about the third element. We had to show you the defendant failed to use ordinary care to protect its employees. Ordinary care. That's the kind of care an ordinary person would take in the same or similar circumstances. Folks, I want you to think about who's making the decisions at this store. It's the owner, Reese Geller. Now, you met Mr. Geller today. He sat in front of you. He looked into your eyes, and you got to learn what his priorities are. You'll remember that when I asked him questions, I asked him right up top, right at the beginning, you care about your employees. You would do things to keep them safe if you could. He said yes. But then as I asked him about all the things he could have done, the steps he could have taken, what was his answer over and over and over again? It's not my responsibility. Folks, I was clear. I asked him, is it that you're only doing what you're legally responsible for? Or is it that you actually care about your employees and want to keep them safe? He answered that question the wrong way. The fact of the matter is, there are legal standards, there are laws, and we showed you that their conduct breaks those laws. But the real standard at the heart of this case is that ordinary care standard. So even if he thought he didn't have a legal obligation, but he thought he should anyway. He thought he should if he cared about his employees. He thought he should if it would be reasonable to keep them safe. Folks, that is negligence. It's as simple as that. I expect that in a couple of moments, defense counsel will come before you, and they're going to try to make this about anyone but themselves. They're going to talk about their landlord. They're going to talk about Mr. Gilmore's own actions in the dark in that 12-inch space. But when they do, I want you to remember who is really responsible for what happened. Every time they blame their landlord, I want you to think about this part of the jury charge. The part of the jury charge that talks about control. Because you're going to learn that there are a couple ways to prove control. It can be proven by a contractual agreement, what's written down in a lease, or it can be proven by actual control. You heard who actually controlled that area. You heard who cleaned that area, who used that area. The only people who were in that area, it was the defendant's employees. Folks, when they come up in a moment and talk about a lease, piece of paper, you'll have a choice. To believe that piece of paper or to believe reality. I have faith that you will make the right choice. So at the end of this trial, you're going to get a verdict form. It's going to ask you who's responsible. We are going to ask you to mark yes for chimes.
Counsel, 12 minutes have elapsed. You have 2 minutes remaining. You're eating into your rebuttal.
Thank you. We will ask you to mark no for Kermit and no for Mr. Gilmore, because they could have taken simple steps. They just didn't. Thank you.
Thank you. Defense counsel, are you prepared to proceed?
I am, Your Honor.
Please press forward.
Members of the jury, at the beginning of this trial, I told you that when I came before you again, you would know 3 things. First, that loading dock was not under the control of Chimes department store, but rather under the control of the landlord. Second, that the regulations you heard about today would not apply to that loading dock. And third, that it was the plaintiff's own choices that actually caused his injuries. The landlord controlled the loading dock, and the plaintiff controlled his choices. Chimes department stores had nothing to do with it. No control, no responsibility, no liability. So let's take the things you learned today one by one. First, in order for Chimes to be responsible for anything that happened here today, it first had to be established that they controlled this loading dock. And we have shown you the opposite. Members of the jury, the plaintiff can say that Chimes used this loading dock all they want, but at the end of the day, use does not equal control. Because as you learned today, this loading dock, it was part of a common area. It was an area that any tenant in that strip mall could use, and pursuant to the lease that Chimes Department Store had signed with its landlord, Kermit Realty, well, it was the landlord who was responsible for maintaining that area. And then not only this, but you saw the site map attached to this lease, and I discussed it with Reese Geller. And Reese Geller told you that, well, the demise premises under that lease, the portion of the premises that Chimes Department Store leases and is responsible for, it's this outline here in blue. That loading dock, it's located where the red X is, outside of the blue outline, and therefore outside of Chimes Department Store's control. Members of the jury, any employee could have used that loading dock. Anyone at all could have used that loading dock. They didn't even have to work at that strip mall. That is the very definition of a common area, and that is exactly why the landlord, and not a specific tenant, is responsible for its maintenance and any relevant repairs. And therefore, members of the jury, this loading dock, if there was anything wrong with it at all, which we will discuss in a little bit, it wasn't on Chimes Department Store to fix it. That responsibility fell squarely on the shoulders of Kermit Realty. Now, because of that, this case is over right then and there. Because if Chimes doesn't control that area, then they have no responsibility. They are not liable, and we can all go home. But members of the jury, even if there was control, the plaintiff has failed to prove any liability here today, because nothing they showed you actually proves that there was anything wrong with the way this loading dock was maintained. Now, before we get into Kelly Danes, I want to directly address something that plaintiff's counsel spoke about on her closing. She spoke about Reese Geller. She spoke about what his obligations were. And she asked him, do you do what you're legally obligated to do? And he said, yes. Members of the jury, let me be very clear. That is all that the law requires a company to do. A company is not required to be perfect. A company is not required to go above and beyond to keep their employees safe. That may be unsatisfying to hear, but that is what the law requires, and that is the standard that you must adhere to when evaluating whether or not there was anything on these stairs and loading dock that made them unreasonably dangerous. So don't let plaintiff's counsel distract you and think that anyone's responsibility here was anything more than it actually was. The responsibility of whoever controlled that loading dock was to keep it free of unreasonable risks of harm. And you saw those steps. They're not perfect. We don't dispute that. But that doesn't make them unreasonably dangerous. All the plaintiff did was show you some pictures and are just asking you to believe that a little bit of cracked concrete makes them unreasonably dangerous. But members of the jury, people go up and down these stairs safely all the time. The presence of something that makes them less than perfectly safe, well, that's not sufficient to show that it was more likely than not that they're unreasonably dangerous. But then what else did they bring you? They brought you Kelly Danes, a mechanical engineer, and she tried to tell you that these stairs violated various codes. Now, first she talked about the IBC, the International Building Code. She talked about all these standards that require railings, but when I confronted her on cross-examination, she had to admit that those codes, they don't apply to whoever doesn't control this area. And as unwilling as she was to admit it, she had to agree with me that if Chimes Department Store didn't control that loading dock, well, then they were not subject to the International Building Code. Members of the jury, do you remember Kelly Danes' cross-examination? Do you remember how beautifully choreographed she was on direct, answering questions flawlessly? But then when it came to cross, then when I confronted her with the inconsistencies in her own testimony, all of a sudden she couldn't remember the answer she gave 2 questions ago. Members of the jury, that's somebody who knows that there are flaws in their opinions and is doing whatever they can to avoid responsibility. That's also somebody who's doing whatever they can to earn their $750 an hour that they are being paid to come here and talk for as long as possible, because the more she talks, the more she gets paid. And then, members of the jury, she tried to talk about OSHA regulations, but they neglected to mention what their expert blatantly ignored, and that's that those regulations, they specifically do not apply to loading docks. So anything she said about OSHA regulations requiring railings on that loading dock, well, you can just forget about that right here, right now, because it doesn't apply. The reason it doesn't apply, well, it's common sense. A loading dock is used to accept deliveries. It's used to accept deliveries of large items. Chimes is a department store selling items. That's what they do. They had to have somewhere to accept those large deliveries. And if that was surrounded by railings, well, then there would be nowhere for those deliveries to go. That's why the OSHA regulations specifically exempt loading docks. And that's why this loading dock was not subject to those regulations. Now, today, plaintiff's counsel tried to argue that this wasn't a loading dock and that you can't just call it a loading dock and it become that, but Chimes doesn't just call this a loading dock. They requested that it be made into a loading dock when they moved into the space in 2005, and they have used it as one ever since. Yes, it used to have railings on it, and when it had railings on it, it wasn't a loading dock, but then it was converted into one and has been used as one for over 15 years. So when counsel says they can't just call it a loading dock and say that it is one, members of the jury, the reality is Chimes is using it as a loading dock, and it's the plaintiff who's calling it not a loading dock and asking you to believe that without showing you that that is true. Members of the jury, that's exactly what Kelly Danes did. She came here and she tried to disagree with me over and over again about whether she would classify this as a loading dock, despite the fact that she herself called it a loading dock on direct examination, another thing she conveniently forgot when it came to cross. The evidence you've seen, it shows this was a loading dock. It's consistently been used as one, and as such, OSHA does not require that it have guardrails. And that also applies to the stairs, because you heard the whole thing was a loading dock. The whole thing was converted in 2005, and the whole thing has been consistently used as such since then. Now, members of the jury, today we brought you Perry Hayden, an actual OSHA investigator who has investigated thousands of workplaces to determine if OSHA safety standards are being followed. Now, he explained to you that those regulations, all those regulations Kelly Danes tried to talk to you about, they don't apply because this isn't a loading dock. And he explained to you that in 2018, when he conducted his investigation, he saw everything that the plaintiff claims makes this loading dock so dangerous. He saw there were no railings. He saw there was chipped concrete. He probably saw the paint that for some reason plaintiff claims is relevant here today. And he didn't issue any citations. That's because in his professional opinion, he determined that there was nothing to warrant a violation of any of those federal regulations. And remember, unlike Kelly Danes, well, Mr. Perry, he wasn't paid thousands of dollars for his testimony here today. He performed an investigation 2 years before the accident at issue here today even occurred. So his findings, they have nothing to do with this trial. They were completely neutrally arrived at. And it was reasonable for Chimes Department Store to rely on those findings because they were from a federal government agency whose whole job is to determine if workplaces are safe. So when the plaintiff tells you that Chimes knew or reasonably should have known that there was something wrong here, well, how? Because a federal workplace safety officer told them everything was fine. And the plaintiff focused on the light here today, but members of the jury, for some reason, that employee misspoke. She made a mistake, and we're not exactly sure why. But had the results of Perry Hayden's investigation been different, had he issued a citation, well, Mr. Geller told you here today, he would have told the landlord. He would have done what he was supposed to do. He would have informed the responsible party that a change needed to be made. That is perfectly consistent with the fact that Chimes did not control this area, and it is consistent with the fact that according to the government investigator, well, their area, it was up to code. There was no reason for them to think any different. The plaintiff also pointed to a previous incident on these stairs 9 years earlier. Members of the jury, we don't dispute that happened. But 2 falls on one set of stairs over the course of 9 years, that doesn't prove unreasonable danger. It proves that people fall. Even in reasonably safe spaces, accidents can still happen. So those 2 facts without more, they don't show unreasonable danger. They don't show a responsibility to change anything. And then the plaintiff pointed to the light. And once again, members of the jury, it's abundantly clear that light, it was not under the control of Chimes department stores. That switch was located in a different area. They could not have turned it on and off at the time. That was the job of Kermit Realty. The fact that Chimes could have installed a switch, members of the jury, that doesn't mean that they had to in the first place. The fact of the matter is that light switch and that light, they were in areas outside of Chimes's control. So the plaintiff cannot now come here and say, well, if it was feasible for you to do something, that must mean you were responsible for it in the first place. That is not what the law says, members of the jury. So don't let them distract you by trying to over-exaggerate the burden and the responsibility that fell to Chimes department stores. Chimes had no control. They had no responsibility, so they can bear no liability. Members of the jury, there's one more thing that you learned about today. The unfortunate truth that Jordan Gilmore's own choices are what actually caused his injury. Now, we are in no way saying that Mr. Gilmore is anything other than a good man, and we understand wanting to hold someone responsible when an accident happens. But your job today is to look at the plaintiff's actions and determine whether he acted the way a person with ordinary prudence would in his circumstances, and the facts have shown that he did not. Because on January 23rd, 2019, he chose to go outside for a smoke break. He could have gone to his car, he could have gone off premises, but he chose to go outside. He went down the stairs in the dark, in the cold. He smoked a cigarette and he headed back up those stairs. And when he came up those stairs, he could see that half-open door. He could see that with the door open that way, he only had a little bit of space to maneuver around that landing. It was a landing he'd been on thousands of times before. It was a landing he knew didn't have a guardrail. Now, he could have chosen to have Riley open that door all the way, or close it all the way, or have Riley move, anything to give himself more space. But that's not the choice he made. Instead, he chose to scoot around that half-open door, to step right up to that ledge that he knew had no protection. And unfortunately, he slipped and fell and hurt his knee. But members of the jury, that's the result of his own choices. Chimes department stores had nothing to do with it. Now, it's very understandable to hear that somebody's been hurt and think that someone else must be responsible and want to hold someone else responsible. It's only human. But today, the evidence has shown that Kermit Realty, LLC, is responsible for that loading dock, and that the plaintiff is responsible for their own choices. Kermit controlled the space, and the plaintiff controlled his choices. Chimes department stores had nothing to do with it. So when you get to question 1 on the jury sheet about whose negligence caused this accident, you can look at the facts and the proof that you have seen today and confidently answer no for Chimes department stores and yes for Jordan Gilmore. And as for Kermit Realty LLC, we suggest you answer no as well. Because while we have shown you that Kermit was responsible for the space, the plaintiff has not actually shown you that they failed to fulfill their responsibilities. But either way, members of the jury, when you get to question 2 on the verdict sheet, you can assign 0% responsibility to Chimes department stores. They had no control. They had no responsibility, so they can bear no liability. Find Chimes department stores not liable.
Thank you, counsel. Ms. Forster, rebuttal. You have 1 minute and 30 seconds remaining. You may proceed.
Thank you. Defense counsel said a company is not required to be perfect. Folks, that's true. But we're not asking them to be perfect. We're asking them to do anything. You don't want to install a railing? Okay. Install a hand railing on the other side. You don't want to put in a light switch? Okay. Buy a lamp. You don't want to do anything. You don't think you have control of that area? Okay. Pick up the phone and call your landlord. They weren't willing to do that. They weren't willing to lift a finger. Now, Ms. McQuiggan says companies don't have to be perfect. And that might be unsatisfying. We just got to live with it. Folks, that is not true. You, the members of this community, you have the power. You can decide what companies have to do. You can decide if you think that companies should have to take simple steps to keep people safe. All you have to do is say so. All you have to do is hold them accountable. Thank you.
Thank you, counsel. All right, at this time, I'm going to go ahead and ask for each of our scoring members to please complete their ballots and make sure they get them over to Kathy and Robert. If you can please turn your video on after you've submitted your ballot so that we know that your ballot has been submitted. Thank you, everyone.
Your Honor, I believe you're on mute.
Yeah, I was on mute. Not helpful. Okay, so I want to go ahead while the ballots are being tabulated, allow our scoring judges to go ahead and introduce themselves. Matt, why don't we begin with you? Why don't you introduce yourself and tell everyone where you're from and what you do?
Sure. Hi, everyone. I'm a intellectual property litigator from Dallas, Texas. And I've been doing that for about 12 years. I think y'all did an absolutely fantastic job. Totally deserve to be here. I've been judging this tournament for 6 or 7 years now. I forget how long, and y'all are some of the best contestants I've seen so far in an absolutely fantastic national tournament. I judge about 2 national tournaments a year, I try. And so kudos to you. Congratulations. Are we giving comments at this point, or?
We can give comments. I've been asked for us to limit each of our comments to one comment that might be helpful to them in the next round.
Okay, great. I'll start with Ms. McGuigan. I think you'd probably need to be a little bit more aggressive in your objections and responses. You missed a couple of opportunities. I saw just because you got it in, you got the objection in after the question was asked. So just keep listening and jump in very quickly when you hear it. And also in the responses, I would just go ahead and jump in once the opposing counsel has clearly stopped talking and made the objection. Jump in and just start with the response, or else you may not get the opportunity ever. And then as for Mrs. Foster, I thought it was a little confusing in the cross of the expert, and you relied on it ultimately in the end, where you started the calling something doesn't make it something. And I think that related to the doc. I'm not sure you need the doc. I'm not sure that's what really the case is about at the end of the day. And also, if you start getting into an argument with your expert, you're going to use a lot of time. And I'm not sure it's the most important thing for your case. So those are my comments, and thank you all.
Thank you, Matt. All right, Rhonda, I'd like to come to you now. Do you mind introducing yourself, kind of telling us a little bit about what your practice is, and then as well, if you can give each of our litigants a comment that might be helpful to them in the next round.
Thank you, Judge. My name is Rhonda Thompson. I am a commercial litigator, so I represent defendants who've been sued and prepare and take their cases to trials. This has been very interesting for me. You both did a fantastic job. Well done. My only comment to both is try to reserve a little bit more time at the end for closing. For this kind of competition, that's going to be pretty important. So if you could reserve some more time for that, that probably would be most helpful, but otherwise, well done.
Thank you. All right, Lenny, can I come to you now?
Sure. Can you hear me?
We can.
Awesome. I thought both of you did an outstanding job. I mean, really, really good. I echo what Matt and Rhonda say. My only suggestion for you, Ms. Forster, is on your closing, pace yourself a little bit with your tempo when you go up and you go down. Just make sure you change your inflection of your voice at certain times. And then Ms. McGuigan, on your opening, your theme was great. But then your closing was awesome. But on your opening, go ahead and give a little bit more inflection in your voice at key points that you want to hit the jury on. So, but both of y'all did great. I was very, very impressed.
All right, I have one more judge, Ms. Moxley. Do you mind introducing yourself and tell us a little bit about yourself, and then one comment for our litigant?
Of course. I echo what everyone said. You guys did a great job. I'm Tara Moxley. I am a labor and employment lawyer here in Dallas. I work at a woman-owned law firm, so I am super psyched to see a stellar team of women, both teams with women in this stage of the competition. Great job. The comment that I would give is kind of for both of you is both in your open and your closing, and as you were examining your witnesses, there was some legalese built into that I think you can avoid that might make it easier to follow. I mean, obviously we're all practicing lawyers and we all know what you're saying, but to give it a little bit more real world feel, Ms. Forster, I think especially when you were cross-examining the store owner, you kept referring to his store as the defendant, as opposed to just, referring to his store or what he owned. that just referring to the plaintiff and the defendant with their names, I think is more helpful. And then when you're referencing back to something you did on cross or something you did on direct, to me, it's just more natural to say, well, as Ms. Forster was questioning the witness, as opposed to referencing cross or direct, it's sometimes harder to keep track, especially for lay jurors, to keep track of, well, now what is cross? What was she referring to just sort of orient the audience to that. But great job.
All right. Thank you, Ms. Moxley. All right, I'll go ahead and introduce myself. I'm Christine Novak. I am a magistrate judge for the United States District Court for the Eastern District of Texas, Sherman Division. I've been on the bench for a little over 6 years now. I'm obviously, like everyone else here, a Baylor graduate. I did complex commercial litigation for a number of years before I took the bench. I thought both of you did an outstanding job. And at this time, I have received the tabulation of our ballots, and I'm prepared to announce the winner. So I'll go ahead and congratulate at this time our plaintiff's counsel, Ms. Jenna Forster. You're going to be advancing on to our final round. Congratulations.
I just want to say thanks so much, Carolyn. You're an incredible advocate, and this was I was scared. So congrats to you. You're incredible.
Thank you. Good luck.
All right, Jenna, I need for you to stay on the video. The people who are running the tournament are going to come on and speak with you about the next round. At this time, I believe all of my judges, you are free to move about the cabin, so to speak. So thank you all for being here. It was such a pleasure to see some of y'all again. And Ms. Forster, if you'll just hang tight, I'm going to have someone here to speak with you, okay?
Thank you,
Thank
Honor.
you. Thank you. Bye-bye.
Bye, everyone.
Good to see you, Judge.
Hey, Matt, it was nice to see you too. Take care, okay?
You too.
All right, Jenna, my understanding, the winner of the other round was Zoe Appler. You all have played each other. Okay, so you're side locked. So you will be the defendant in the final round, and she will represent the plaintiff. The woodshedding will start at 2 o'clock, an hour before the round, just like it did this morning. And I will get you the witness contact information and shortly. The trial will be in this courtroom. So it's in courtroom 1. So that same Zoom link that you used to get in this morning, we'll work to get you back in here for the trial. Is there anything else you need to know? I'll shoot you an email shortly. Nothing else changes. So no changes in the pretrial order. Everything's the same.
Okay, sounds good. I think I'm all set.
All right. Congratulations. We'll see you in a little bit.
All right.
Bye.